Somehow or another, the internet went out in the hearings room and we all became frozen. Ms. Stafford, can you just start over? I apologize.
Sure. It was a bit of a jumbled start, so I'll take the opportunity to rephrase.
Okay, we will get restarted at this point. That's what I thought.
Where was it?
Go ahead.
Thank you, Chair Robbins, and good afternoon again, Commissioners. In my presentation, for my closing presentation, I will first start with the requested corrective actions, and then I will move on to the more formal closing argument that we have prepared as a result of this phase of the hearing. Briefly, I wanted to discuss the Commission's request for the outstanding corrective action list at the remaining remediation projects associated with the NOAVs that were at issue in this proceeding. A document was recently shared with Hearings Manager Larson, as well as e-filed into the Commission's e-filing system that sets forth a specific listing of work that staff is looking for KPK to complete. And as I was getting to shortly before everything cut out, I wanted to briefly summarize the asks that staff has put forth here. Overall, staff is requesting that all work should be performed by a qualified environmental or engineering firm with expertise in site investigation and remediation associated with oil and gas sites in Colorado, and shall perform required reporting through the COGCC e-form system on behalf of KP Kaufman Company. Staff notes that COGCC does not consider Kaufman Well Service or any other subsidiary of KP Kaufman Company to be a qualified environmental firm. And except where there is a date specified or where it is requested that completion be attained immediately, staff requests that KPK complete the following work within 90 days. And Commissioners, we have set forth the listing of NOAVs with associated opening corrective action, noting first the UPRR 43 Pan Am site, also known as staff has been referring to as the near miss NOAV. Generally asks for KPK to provide an implementation schedule, complete remedial excavation, provide necessary site diagramming, and also reporting logs for groundwater monitoring wells, and to provide quarterly updates as necessary. For the soil spread field site, staff is requesting that KPK provide additional background determination for various elements present in the soil there, and provide all requested information due in the next supplemental form 27. Next, for NESU Consolidated, staff is requesting that KPK comply with the conditions of approval that were applied to a previous supplemental form 27 document, and provide all requested information due in the next supplemental form 27 by a date certain, which is listed in the document that we've filed. For Grant Tank Battery, staff is asking that KPK create and subsequently maintain a scale site map that shows a variety of items listed in our submission, comply with rules 913D and E. Per rule 913B2, determine the horizontal and vertical extent of the contamination, and perform and implement other field analyses and quarterly monitoring as we've set forth in other documents, other supplemental form 27s that are on file. And then staff's last ask is related to the Facility 4 North, which is order number 1B728. There are several corrective actions that remain outstanding at that particular site. And because the because that order deals with one of the rules that should be considered in the pattern of violations analysis, staff is requesting that all work associated with that site be performed as well. And if you would like, we will be able to make Mr. Axelson available to discuss these open corrective actions in more depth following closing arguments at your request. And now, Commissioners, I'd like to move to the discussion of the information that you've heard over the course of this hearing. Commissioners, over the past day and a half or so, you have heard presentations regarding staff's requested relief in this enforcement action against KP Kaufman Company. Having found that KPK committed 22 separate violations of Commission rules in the earlier phases of this hearing, you have now been tasked with determining what corrective actions, if any, to impose, and whether you have enough information before you that shows that more likely than not, KPK has engaged in a pattern of violations. Let's recall for a moment why we're here. During the spring of this year, staff brought to your attention an enforcement matter that required your direct oversight because of the depth and breadth of allegations at issue. As staff has since made clear, KPK has a systemic and widespread problem operating in compliance with COGCC rules. This problem is apparent in prior orders entered against them, and most importantly, based on the 22 separate violations found against them during the course of this hearing. The 901A order only compounds the seriousness of KPK's noncompliance. You heard from Mr. Farron, Mr. Axelson, and Director Murphy. Mr. Farron broadly explained what it means to have a pattern of violations and walked you through the different ways in which KPK has engaged in such pattern. Coupled with prior orders, KPK has engaged in a pattern of violations of prior Rule 324 Big A little a. And Mr. Farron was struck by the similarities of KPK's first documented violation to some of the violations that were found in the most recent case. Impacts to a perennial stream, failing to submit required environmental documentation. Coupled with prior orders, KPK has engaged in a pattern of violations of prior Rule 906B, which requires timely and accurate spill reporting. Here, KPK is substituting its own unreliable and poor judgment for that of the regulator in deciding what to report and when to report it. In this current case alone, patterns of violation of Rules 901C for failing to provide environmental documentation, and for Rule 907A for failing to properly store exploration and production oily waste. Through prior orders, there's a pattern. Through this enforcement matter alone, there's a pattern. Mr. Axelson spoke to you about the dire situation leading up to the issuance of the Director's 901A order in April of this year. Multiple remediations open for months, even years. Close to sensitive receptors, schools, houses, wetlands, streams, sensitive wildlife habitat. The list goes on. Open excavations with inadequate fencing, free product just sitting there after 24 hours, stockpiled oily waste with no stormwater protections. In 21 of these 29 situations, these impacts were discovered by someone else. And what's happened since then? 2 sites of 29 have achieved closure. 27 of the 29 remediations remain open. No remedial progress at 6 sites. 19 sites with open excavations. There's a theme here. Some might even call it a pattern. And in response to staff's testimony, to all of the information in the record, KPK continues to minimize, they continue to deflect, and they continue to make excuses. KPK points to violations of, quote, general and minor rules, arguing such conduct hardly constitutes a pattern, while failing to acknowledge the threats to public health, safety, welfare, the environment, and wildlife resources from each of these violations. And they point to issues gaining approval on correcting identified issues at their locations or performing certain remedial work. But they fail to acknowledge that it is their own understaffing, inexperience, lack of training, and incomplete submittals that play a major role in the situation. KPK claims to come to repeated impasses with staff regarding the rules, without acknowledging staff's expertise in working with its own rules. KPK relies on their internal training, or overall lack thereof, and pushes back on basic things. KPK has consistently stated that the commission and staff now has its full attention. Yet KPK continues to blame their sustained and documented inability to comply with COGCC rules on anything and everything but their own conduct. COGCC is picking on us, they say. KPK says COGCC won't meet with us. KPK says COGCC staff won't hold our hands and tell us what to do. You heard testimony from KPK leadership claiming that KPK's pattern and practice of non-compliance is all a communication problem. This isn't a communication problem. It's a competence problem. There are risks and consequences that come with operating oil and gas wells, and operators must be prepared to respond to these situations without endless meetings, without unsustainably taxing COGCC staff resources. Other competent operators don't have similar problems because they have the expertise and staffing to do what is necessary to comply with the rules without needing staff to act as their personal environmental consultants. Other operators also have a history of doing things correctly, so there is a level of trust present that makes things faster. The trust staff has had in KPK has been significantly eroded here, and it will only be rebuilt slowly over time. You also heard KPK testify that they use their well servicing company to address environmental issues. And while those people might be great in eking out another barrel of oil from KPK's aging assets, it's clear they do not understand sampling protocols, reporting obligations, and basic E&P waste handling protocols. And KPK's supposed environmental training has clearly been ineffective. KPK tries to paint themselves as a responsible environmental steward who has had some missteps but has now turned a corner. But nothing could be further from the truth. It took this enforcement proceeding and the 901A order to get their attention. It shouldn't have been that hard. As part of this hearing, KPK has set forth information regarding their inability to pay. And while staff has not taken a position on the Commission's determination on this particular matter, I would like to note a few things. Typically, when staff requests information about an operator's inability to pay, we ask for a written narrative, financial statements, bank statements, a federal income tax return, and an operator financial summary. We would ask the Commission to look long and hard at the information that KPK has submitted to you to support their claim here. Further, with respect to inability to pay, KPK has repeated the phrase cash business multiple times during this hearing. But when I hear that, I hear we're too big to fail and that they're undercapitalized and can't comply. Put another way, as we've said in our initial brief and our response brief to this pattern of violation hearing, staff feels like they are holding us hostage. While we haven't taken a position on KPK's inability to pay arguments, we do ask that you order KPK to, at the minimum, complete the corrective actions outlined by staff on a tight schedule. Recall Mr. Axelson summarized old Rule 906 that required operators to immediately control and contain all spills and releases and clean them up as soon as possible. There is no income qualifier to that rule. If they can't do that in a timely manner with internal staff, and if they can't pay for it using operating funds, they need to find a different way to make sure the work gets done. Commissioners, I told you yesterday morning, as set forth in the pleadings and the documents in the record, and in prior orders and accompanying information available in COGIS, KPK is a repeat rule offender that requires additional corrective actions to return to compliance. Multiple commission orders establish their history of violations. And you have found, as a result of this hearing alone, that KPK has committed 22 separate violations of commission rules. KPK has engaged in patterns of violations prior to this case, within this case, and as a result of the findings of this case. Staff has met its burden here to show you that more likely than not, KPK has engaged in a history of noncompliance with this commission's rules. KPK has engaged in multiple patterns of violations. Back in August, I told you we wanted you to order KPK to live up to its obligations of the people of Colorado because they have clearly stopped listening to staff. KPK is unreliable, incapable, and impactful. and KPK has engaged in a pattern of violations. Recall that the Commission's mission has changed since 1994 and 2014, and since the enactment of Senate Bill 19191 in 2019. The background of the pattern of violations rule is helpful, but only to understand the history of the rule. The application of the rule has to be viewed through the lens of Senate Bill 19181. On behalf of staff, I ask that you find KPK has engaged in a pattern of violations, apply an aggravating factor to the current penalty, suspend KPK's certificates of clearance, impose sweeping corrective actions, and order any other necessary and appropriate relief. Thank you.
Thank you, Ms. Stafford, for that closing. It's not typical to have questions for closing, but we're a not typical body and we've been asking questions all along. So I'll look to see if my fellow commissioners have any final questions. Okay, seeing none. Mr. Jacobs, did you and Mr. Mueller figure out who was going to go first?
Yes, Mr. Mueller is going to start with our closing argument, and then I'll turn to our submission e-filed just prior to 1 o'clock.
Okay, Ms. Larson, if you could email that submission to us as well, then we can be looking at it when Mr. Jacobs goes over it. We had the same opportunity to look at staff's when Ms. Stafford was going over hers, so that will be helpful and we'll be able to open that up. So glad to hear Mr. Mueller is going first. That'll give us a chance to get that document.
Very good. Thank you.
Go ahead, Mr. Mueller. The floor is yours.
Mr. Chairman, thank you for that. Respectfully, this is not a proceeding that has created the kind of record that supports the kind of finding that is being solicited by staff. The patterns of violation that are actual violations are few in number. 3 violations in the current 8 of Rule 901C, 3 violations of Rule 901A. That's the kind of pattern that is being alleged here and for which draconian sanctions have been solicited. To get a pattern of violations of 906B, staff reached all the way back to 1999 so that they could find 3. You heard Mr. Borgen testify about the history of the bad actor rule, and you understand that it was the intent then, and even after it has been reenacted in the history since then, that this is a draconian remedy that is reserved for genuine bad actors who have displayed contempt for the commission, for its rules, that have behaved flagrantly in many cases, that have ceased operating and left the state. The patterns that are alleged here are few and far between, and most of them are leveraged by reference to the 901A letter. Those aren't violations at all. With any luck, I'm going to share my screen just to make a point.
Okay, we'll stop the time as you're getting your screen sharing. Okay, we can see your screen.
Good. Thank you, Mr. Chairman. This is the summary of violations that was filed last evening, I guess, by staff. It's misleading in this regard, commissioners. The column that says spills with Rule 906B reporting violations, and then it tallies those. If you look at actual violations in the record, those are set forth in the column on the right, highlighted in yellow. Those are actual violations. They total 5 if you go back to 2015. Staff counted 22 because they are including as violations the topics that are listed in the 901A order. Those are not violations, and you know our position on that. We don't think you should be considering those. But the pattern has been made, respectfully, commissioners, it has been made to sound far more egregious than it actually is. You also heard Mr. Borgen describe that, I'm going to unshare, describe the process that the commission should go through before it issues this kind of a finding. It's not the kind of thing you do in phase 3 after you've litigated the subject matter, the prior 7 NOAVs. You don't come in phase 3 and say, oh, and by the way, we didn't really talk about it when the evidence was coming in, but there's a pattern here and you ought to suspend their certificates of compliance. That's not the proper procedure for this. Mr. Farron said in his remarks that this is the first time they've tried to employ the extraordinary weapons under the pattern of violations rule in a situation like this. That having been the case, then it was imperative on staff to have laid the groundwork for that, to have queued up this hearing in a fashion so that we really were focused on the issue of pattern, because after all, that's the issue that is the most weighty and the most concerning for the operator, certainly. And as you can hear from Ms. Stafford, it's also of great interest to the staff. We should have been talking about this from the beginning. You know, we take exception to the fact that it wasn't really raised until the end of June. We don't think it's properly before the commission at all. But your honors, I'm sorry, commissioners, we don't think it's the kind of egregious pattern that requires the kind of extraordinary remedies that have been floated, and respectfully suggest you don't get there. It almost seems baked in. There is a little bit of a presumption at this point, I think, that this is going to go down the way it is been pitched, but I'd submit that you look long and hard. I don't think the pattern really exists as it's been described. But I want to talk about what I think is a little bit more important, because frankly, it's the place where I think we ought to try to come out. Finding the kind of pattern of violation and enhancing already steep penalties and fines is not going to achieve the goal that I think everybody really wants to achieve. You heard Mr. Boygan, you heard Dr. Considine describe the philosophy behind fines and penalties in enforcement regimes, and the purpose being to achieve behavior change, improve conditions, not to punish, not to put people out of business. You've heard evidence and testimony about KPK's ability to pay. You recall from Mr. Wise that the fine of $800,000 spread over 5 years is manageable for KPK. That's money that's not going to be spent on cleanup, but it's a fine that they can pay. But it doesn't really achieve the goal that, again, submit is what everybody really wants. There's an old adage, a relationship advice that you've probably heard before. It's posed in the form of a rhetorical question. And the question is, do you want to be right or do you want to be happy? Both parties in this proceeding want to be both. I will acknowledge it. KPK takes some exception to the way they think they have been unfairly treated by staff, that they've been demonized, they can't seem to do anything right, and they don't like that. At the same time, you've heard almost every witness from KPK acknowledge that mistakes have been made, that they can do better, that they would like to do better, they want to find a way to get there. They're tired of being the object of staff's wrath. And you've heard from staff that KPK is the poster child for bad actor, to quote Mr. Farron. And you just heard Ms. Caitlin's closing remarks, and there's not much love there. But you also heard Mr. Axelson say, look, we're more interested in compliance than we are in the size of the fine. And so with setting aside the parts where the parties disagree, what you find is there is a consensus as to what would make them happy. Staff would like us to get into compliance, and KPK would like to get into compliance. You're not going to get there by suspending their certificates of operation, by pinching off cash flow from the 901A wells that are closed in, but we can get there with other methods. We looked with interest at the corrective actions sheet that Mr. Axelson lodged also last night. We think all of those kinds of remedies are on the table. We put those kinds of remedies on the table early in the process when the parties were trying to have settlement dialogue. We are open to those and encourage dialogue around those. You heard Mr. Borgen as well describe other options that don't involve putting people out of business. You can create an escrow fund, a sinking fund. You can have structured settlements that are designed to, again, achieve what makes people happy, some progress towards a compliant situation at all of these sites. Mr. Borgen even, I think, suggested that a mediated dialogue between the parties might be a way to get there. But the point is, it seems to me that's where we ought to be headed. And I was very heartened to hear your remarks, Commissioner, yesterday when I heard you asking questions that seemed to strike or struggle to strike the balance between how the commission is to act as an adjudicatory authority on the one hand, but also is there some role for them to play to mediate or to negotiate to come up with a solution rather than just penalizing two angry parties. And I think that's the right direction for this commission to be looking at. We were heartened by the 2-hour break that you gave us to talk about getting plans and notions out there by which we can try to come into compliance and have that dialogue. And we think that's the direction you should go. You have the option to impose penalties, but not, or to assign penalties, but not to collect them. You can suspend some part if you think motivation is required. There are things you can do that are going to be constructive and get us to the place where we want to be happy and not simply, as I say, choose up sides and one side or the other, or both are going to be unhappy. You do have indeed a mandate to protect the public health, safety, environment, and wildlife. You also have a mandate to do it and to regulate industry in a reasonable manner. And suspending certificates of operation, imposing fines that can't be paid, those kinds of things in these circumstances with this actor are not reasonable, and I don't think it's the direction you should head. With that, Mr. Commissioner, I'll stop the clock and turn it over to either questions or to my colleague, Mr. Jacobs.
Okay, why don't we stop the clock and look around the room here and see if anyone has questions with regard to the closing before we hear from Mr. Jacobs concerning corrective actions. Commissioner Messner has a question.
Thank you, Mr. Chair. Just a point of clarification, because it did come from my mouth. There are 22 confirmed violations now associated with the NOAVs. And I think that you had indicated that that was not the case and that they were in the 901A, and I think that's incorrect.
It is. If I said that, I misspoke.
Okay, thank you.
Any additional questions? Thanks for that clarification, Commissioner Messner. Okay, with that, we will allow Mr. Jacobs to present with the remaining time that exists that was granted to KPK.
Thank you, Mr. Chairman. I would just add that the document that Mr. Mueller was referring to and screen shared also was e-filed, and I believe it was sent to Hearings Manager Larson, if you want to refer to that annotated chart of staffs from last night.
Okay, thank you.
Commissioners, Chairman Robbins, we've done our best to be thoughtful in using the two and a half hours you provided during the break to address corrective actions by NOAV locations. I'm going to pull up that document as well. I know you've been able to share it or see it and pull it up on your own monitors, but you should see the first page of that. It's Respondent Operators Corrective Actions by NOAV Locations. This is adapted from our Summary of Progress document. 3 of the NOAV locations, the 7 at issue, are fully closed, and those are documented at the bottom. But the real punchline here and the part that is reflective of our hard work over the break is this framework up front. Staff has asked for a hard 90 days for certain items, and I tried to take good notes when Ms. Stafford was going over those points of requiring all work by an engineering firm, double to triple, or excuse me, completion within 90 days, and the different sites including Facility 4 North, which is not an NOAV location. So happy to address that time permitting. But really, here we have laid out a framework for what we think is constructive and doable. This, rather than giving us a hard deadline of 90 days to get everything done, it is a process where we submit a plan, a revised plan. We do have plans already in place, Forms 27, the most recent ones. Staff would then approve that plan. We would be able to, or comment on it. We could revise it based on comment. We would obtain remaining or outstanding third-party approvals. We've got a county road approval issue in one location and an owner, I think, approval in another. We would then, subject to getting those approvals and working hard, showing best efforts to do that, implement the plan. And that would be subject to a 90-day clock or another time period negotiated that is site specific. And we call out Grant Tank Battery as a good example of a site that couldn't possibly be done in 90 days because we don't even know the extent of contamination there yet. part of the plan would be the nature and extent of contamination. And I think we're in agreement with staff on that. I believe Ms. Stafford pointed that out when she was talking about Grant tank battery. So I think we're close to being in agreement, but we've built in some detail, such as being able to get a good cause extension on the 90 days if we ask for that before at least 30 days before the end of the 90 days. That during staff review of our plans and deliberating on them, that the 90-day clock stop, so it's not working against us, and we're afforded the full 90 days. And then once we submit get the work done, we have it 30 days thereafter beyond the 90 to submit a closure request to complete. And we think that's a workable framework. And that's the sort of thing that could be a framework to address all 4 of the remaining NOAV locations. This again summarizes our progress at these 4 locations that remain open. Then here are the 3 that are already closed. Closure's been approved and the dates provided there. We added, because there was a question about expense, our estimate of future expenditures. These are conservative. UPR 43 Pan Am we're up to 100,000. We think ought to do it. It might be less. We've got a real problem trying to estimate Grant tank batteries. So there's a big caveat there at 1 to 2 million. It might come in lower. It might be larger. And I certainly want to clarify that, should we obtain information in the course of that work to demonstrate that it is not from KPK operations, either historic operations, but it is the result of third-party historic operations, we're not committing to perform all the remediation here and now. We might agree to do that in a negotiated process moving forward. We certainly could provide the information that we gain in characterizing the site and getting going on that remediation to assist staff in pursuing a third-party responsible operator if the data support that. If it's inconclusive, we'll likely have to move forward and remediate. But we certainly, by estimating this, don't want to imply that we're absolutely committing to doing all this work, even if we didn't cause it. And we think that's reasonable, and you should take that into account. But we'll move forward in good faith on that basis. I also do want to just address a few remarks by Ms. Stafford on staff's behalf regarding corrective actions, especially all work by a qualified engineering firm. I understand they have concerns about training for Kaufman Well Service. We need to get those people trained up. We're committed to doing that. We believe that a cost-effective solution would be to bring in a firm like John Peterson's. You remember hearing from him. He was one of our experts on historic contamination, and have them supervise and project manage each of the locations, make sure that our people are trained up before they do work on those locations. This would be a combination that leverages the personnel and equipment and capability of Kaufman Well Service, but it addresses staff's concern regarding qualified supervision, oversight of these sites, sampling protocols, the whole 9 yards. It would all be done according to Hoyle, according to your COGCC rules. And we're committed to doing that, but we'd be paying double to triple the expense. We get less done with the same amount of money, and money is an issue, as you know, from our ability to pay testimony. And lastly, I would just like to point out that the kinds of financial information that Ms. Stafford said staff would want to see, this is the first time we've heard this. We tried to engage a forensic accountant jointly so that we would share everything. They didn't want any part of that, so we had our forensic accountant be our expert. And we provide—
I would object to Mr. Jacobs's discussion of settlement discussions. I think that's inappropriate.
Well, we wanted a joint forensic accountant for hearing purposes as well. The dollars are what they are. It can be divorced from settlement, and there's no substance of settlement terms in anything that I've said. So I object in return to Ms. Stafford's interruption, for one. They never asked for tax returns. We've been very forthcoming. We've gone into executive session once, and we'll do so again if it suits the commission's pleasure. Mr. Kaufman will speak to any issue you have, and you'll have the unredacted Exhibit 12 to examine regarding royalty, reserves, values, et cetera. So that was my last point. It's the first I've heard of it. We tried to be very forthcoming and transparent while protecting confidential business information, of course. And with that, I'm happy to entertain questions about our corrective actions by NOAV document submitted just prior to 1 o'clock. There were a couple of blanks at the bottom, you'll notice, on estimated expenditures to date. And I know that our CFO, Mr. Stoltz, did just email us some information. If we could take a break after I'm done here in just a moment, I may be able to give you some numbers to fill in the blanks there, or at some other time before you close the record. But down here at the bottom, we may have the numbers you need to fill in the blanks there. And with that, I'll stop my remarks and stop my screen share.
Okay. Just on the point about filling in the blanks, yeah, why don't you try to get your CFO to do that for us?
Thank you.
And get that refiled. So at this time, I'm looking to see if fellow commissioners have any questions for Mr. Jacobs on the topics that he just covered. Commissioner Gonzalez?
So I heard from staff and I heard from Mr. Jacobs and saw both their corrective action kind of sheets, but I'm, not being able to read or compartmentalize that information so fast. I'm curious how they compare. Has Mr. Jacobs had an opportunity to compare and contrast what he's offering versus what staff has offered and vice versa?
Mr. Jacobs, will you answer that question first?
I'm happy to, yes. Commissioner Gonzalez, honestly, I'm going off of what I heard Ms. Stafford say and summarizing what they submitted. I've not had a chance to review it carefully. I think we're pretty close. I think we built some ability for the 90-day deadline to be paused or told, awaiting staff review, to request a reasonable extension, just some flexibility in there, and not applying 90 days in any circumstance to grant tank battery, because that's such a big question mark of a project. But I'd like some clarification perhaps from Ms. Stafford as well. And again, I apologize, I've not had a chance to review in detail their corrective actions document. But if I heard correctly, that didn't include completing the remediation. I know Mr. Axelson pointed out that groundwater remediation takes a long time in certain locations, and that would be accepted from any deadline. But removing all source material, getting the plans done, addressing corrective actions within 90 days, I think in most circumstances is doable, provided the framework we've suggested with pausing the clock for staff review and the like is allowed. I think that's a perfect compromise of what staff's asking for and what we're asking for, with the exception being grant and staff review time, for example.
Ms. Stafford, I don't know if you have an ability to answer or if you had a chance to take a look. We're all kind of scrambling here at the end. So did you want to try to provide any perspective?
Sure, I can briefly address a few of the things that Mr. Jacobs is curious about. I do want to at least let the commissioners know that the information that we provided for the outstanding corrective actions are based on a desktop review. We weren't able to go out in the field and verify that these corrective actions are are what is actually necessary out there at this point. And we'll need to, and we're working off of information that was submitted by KPK themselves. So I just want to caution the commissioners there to interpret that accordingly. So these corrective actions might not be all inclusive of the actual outstanding work that needs to be completed out there. With respect to a couple of the comments Mr. Jacobs made, I think the suggestion of Mr. Peterson's firm seems like it could be an acceptable third-party solution here. We've had a brief opportunity to discuss that just over the course of the presentation here. So it's our understanding, at least at this point, that could be acceptable. I do want to touch on this discussion of potential extensions from the commission related to work being done. I don't think it's appropriate that it get memorialized in a document that we're dealing with here today. This is a process that an operator needs to come back to the commission and request specifically through a different proceeding to get an extension. So I want to at least make sure that we're all on the same page here. That would need to be a commission order, and I don't believe the director would be able to grant extensions there. Mr. Davenport can obviously correct me if I'm wrong there, but so I just want to at least make sure that we are all understanding, what the appropriate process would be going forward.
Anything further, Ms. Stafford?
Just quickly turning back to the engagement of Mr. Peterson's firm, from what I'm understanding from staff, if this is to supervise and perform all sampling and reporting work, I think that is sort of the level that we're looking for there. We would basically ask that all of the technical work be performed by this outside third-party consultant.
Okay, thank you for that answer. Any further question? Yeah, Mr. Jacobs.
I might just clarify. I certainly cannot commit Mr. Peterson or his firm to do this work. I've suggested to the client and also raised with Mr. Peterson this kind of role, but certainly if they were not able to reach agreement, we would consider a comparably qualified third-party firm in that role. So I don't want this to fall apart because for whatever reason, WSP and Mr. Peterson and his firm couldn't do the work for whatever reason. So I want us to be a little flexible there. I expect that would be a very good option, and I'm hopeful that it will work out, but I can't commit to it without Mr. Peterson's firm being on board.
Okay, thank you, Mr. Jacobs, for that clarification. Commissioner McGowan has a question for you.
Actually, I think I have a question for all of us in general. So trying to figure out the order of which things are going to be discussed and decided. Assuming that we have found a pattern of violations and assuming that we want to go this direction of some sort of a performance plan, I guess I'm calling it a performance plan. It seems a little short-sighted to me, if this is the direction that we're all going to go in, that we would adopt such plan today with deadlines and deliverables in the span of however much time, with 5 commissioners who maybe shouldn't be making those decisions. And I'm wondering if this is the direction that we're planning on heading in, if it's agreeable to both parties that we send them back and jointly put together a proposal for the commission to approve that has deadlines and deliverables in it. It has an approved project manager that's overseeing this work, that has an attached scope of work with sampling and training deliverables, etc. It has deadlines for corrective actions, for remedial work. It maybe has a final kind of, I get that we're doing back of the envelope, this is how much it's going to cost, but maybe we'll have better cost estimates. So I'm just throwing that out there. I don't know if I'm comfortable adopting a performance plan right now this afternoon with only the information that we have and maybe some more conversation, but maybe the other parties feel more comfortable doing that. I'm not sure. I'd like some feedback.
Commissioner McGowan, I could like to answer or at least provide my perspective on that. AAG Davenport and I have been having some discussions about next steps and moving forward. And I was going to suggest, once we're done with oral argument or closings, that we talk amongst ourselves in a similar fashion. What I was going to suggest is that we take up the pattern of violation issue today, as well as the determination of, if we were to find one, the certificate of clearance or the no new permits, and then the potential aggravating factors for the NOAVs. But I was going to suggest that with regard to corrective actions as well as compliance plan, that we potentially reserve and not finalize a decision on that today. And one thing that I was going to suggest is that we allow one of us, perhaps myself, to serve as sort of a, quote, special master to sort of shepherd these discussions. I don't know that I'm comfortable or that it's fair to send them back to the room where it's just the director and staff and KPK and their attorneys in the room. And I would rather be there to sort of monitor that and get to a product that I could feel comfortable bringing back to the commission as a whole that speaks to all of these detailed issues that we may be going toward. So that was where I was going to go with this. And since you raised it and thoughtful minds think alike, I'm going ahead and saying that now to my fellow commissioners, as well as, I suppose, to counsel of record for both sides, that that's at least where one commissioner was going to try to, suggest we go. Commissioner Messner, I think, also would like to speak to this issue.
Thank you, Mr. Chair. And I appreciate both your and Commissioner McGowan's thoughts. I do think that these conversations are more appropriate during deliberations and probably not appropriate at this stage to have with parties. And so I would be interested in seeing us step away from party presentations or finalizing party presentations and start deliberations so we can have these conversations.
And that's fine. I agree. At this point, we've not had the parties respond, nor do we really need them to. So if there are no further questions for the parties, there's another one. Hey, Commissioner Nanjapa, go ahead.
Sorry, just a quick one, and it's probably probably one that I should have heard or know, but that is that AAG Stafford, when you were going through, excuse me, the corrective actions, there were just five of the NOAVs that we discussed in the current proceedings, and particular actions for those. Is that because the other two are now closed? I just wanted to confirm that.
Thank you, Commissioner Nanjapa. It's my understanding that if there was not suggested open corrective actions at a particular site, that meant that the site was, the corrective actions had been completed at that site. So there was nothing outstanding.
Okay, and I'm sorry, just to make sure that I'm clear. And are you saying that is related to what was reported by KPK, but would need to be confirmed? Or are you saying that that is, yeah, is it more related to your understanding of what has been done, but perhaps not confirmed?
Sure, I'll back up for a second. So if a site is not listed, it has been closed. Those remediation projects are closed. For the outstanding corrective actions that are listed, that information that we have listed there is based on information that, yes, KPK has provided to us and that we understand, and that has formed the basis of our understanding for the work that still needs to be done out there.
Okay. Thank you very much. That's all I had.
Okay, great. Then we will excuse the parties. Thank you all for your thoughtful presentations over the course of this hearing, over the course of the last couple of days. And we will return this to the commissioners at this point for deliberations. AAG Davenport might want to call upon you in terms of whether we should go ahead and close the record, or should we move into deliberations without closing the record in case a question comes back up.
Thank you, Chair. It's been the commission's practice not to close the record until you're very close to a decision, especially given the possibility of further conversations about corrective actions. I do not recommend that you close the record right now.
Okay, then we will not close the record. And we are now quietly amongst ourselves, and we can move into deliberations by commissioners. Commissioners, I still think that the method by which we perhaps should move through this is to start with the thoughts and determination with regard to pattern of violations, and then go sequentially through that down to the point of where we are looking at NOAVs by NOAVs, et cetera. So that's my idea. First, why don't we throw it out to the rest of you guys to see if you have what your idea is in terms of how we run deliberations. And I see that Commissioner Messner has raised his hand.
Thank you, Mr. Chair. I mean, I'm generally in support of that. I think I did have, and give me a second as I pull it up here. So my understanding as far as your suggestion is that we determine whether or not there was a pattern of violation. Should there be a determination that there was a pattern of violation? You have us going to the determination of whether to pull certificates of clearance or not. For me, I would prefer to see that determination of certificate of clearances occur when we talk about the ability to pay in the compliance plan, versus making that determination prior to potentially going through NOAVs to determine whether or not we want to apply aggregate penalty increases for a pattern of violation determination. So I don't know if it's a problem for you all to shift that determination as far as certificate of clearances down into the ability to pay or a compliance plan, but that works better into my thought process.
So Commissioner Messner, can I gain some perspective as to why that works better in your thought process? Because I was looking at it from, if we were to find pattern of violations, at least as I think about pattern of violations, I kind of know where I think I am. And I also kind of know where I think I am with regard to this pulling of certificates of compliance or whatever those certificates of clearance. But I would love to get your thought process, because, you know, we're all not looking at this, well, we're looking at it from 5 different heads. So.
Sure. I mean, the way that I'm looking at it is, and, you know, as usual, I have a lot of thoughts that I've written down that I'm happy to read about this. And so if you want me to go into a dialogue, I certainly can go through that. But generally, without going into that, you know, I will find that there is a pattern of violation. And I am not interested in immediately pulling a certificate of clearance necessarily, but I do want to maintain that authority should we determine that a compliance plan is appropriate, and still be able to utilize that as a remedy or an enforcement option should compliance not be met in a potential compliance plan. And so that's why I'm interested in putting it there.
Okay, no, that I see. So it's a enforcement mechanism or a incentive mechanism that you want to hold in your back pocket. Okay, Commissioner Gonzalez. Now let's just jump right into patterns of violations, guys, and it looks like that's where we're going anyway. But go ahead, Commissioner Gonzalez.
That's not exactly what I was prepared to jump in with, but I was going to concur with Commissioner Messner that I think that, you know, when we think about pulling certificates of clearance or or pulling the ability to get drill permits and consolidating them kind of at the end. It just helps us understand all the levers that we can pull to understand kind of the full suite of remedies. So I was trying to piggyback on what Commissioner Messner was saying and say that I agree with that. So that being said, I'm happy to participate in deliberations. Anyone else?
And I'm comfortable with this direction as well. So we'll dive into pattern of violations and we'll hold back on the certificates of clearance until sort of toward when we start to talk about ability to pay and compliance plan. So with that, Commissioner Messner, you started off. Do you want to give us your thoughts about pattern of violations?
Yeah, I'm happy to. Here's my long answer to a short question. And, and I'm just going to go into this a little bit because this is just the way that my mind worked on this. And so bear with me here, and I apologize if it's not quick and sequential to what a lot of you will say. But I'm going to start by saying that I found much of the facts around this hearing to be very disturbing. We spent 5 days in August hearing evidence and testimony around a laundry list of alleged violations. Through the process, it appeared to this commissioner that there were systematic deficiencies in the organizational structure, communication, and response to violations, and required remediations of sites solely owned and operated by KPK. Many hours of testimony were dedicated to attempting to defer responsibility, place blame on third parties, and to diminish or minimize the severity of the violations and issues at hand. Through that initial process, it was in fact determined that KPK violated COGCC rules in 22 instances. Over the last couple of days, we continued to hear testimony attempting to place blame for these situations on third parties, previous owners, economic downturns, COVID, and COGCC staff. While I did hear testimony today that indicated that there would be wholesale changes in operations, a new ownership of responsibilities, this was intertwined with additional testimony deferring or transferring responsibility for many things. There is a responsibility for oil and gas operators in the state of Colorado to operate in a manner that protects public health, safety, welfare, the environment, and wildlife resources. There is a mandate that this agency regulate in a manner that protects these same interests. It is with these thoughts that I offer these findings and determinations. The Oil and Gas Conservation Act 346121 states that the commissioner or the director shall issue an order to an operator to appear for a hearing before the commission in accordance with section 346108 whenever the commissioner or the director has evidence that an operator is responsible for a pattern of violations of this article, any rule or order of the commission, or any permit. If the commission finds after such hearing that the operator is responsible under the legal standards, it may issue an order that prohibits the issuance of new permits to the operator, suspends any or all of the operator's certificates of clearance, or both. Important to note that when the operator demonstrates to the satisfaction of the commission that it has brought each of the violations into compliance, that any penalty not subject to judicial review or appeal has been paid, the commission may vacate the order. Rule 525D3 states during this pattern of violations hearing, the commission administrative law, the commission will consider an operator's history of violations of the act or commission rules, orders, or permits, and any other factors relevant to objectively determining whether an operator has engaged in a pattern of violation. It also states that an operator's history of violations, the commission administrative may only consider violations confirmed by commission order through AOC or OFV. Rulemaking order 1R123 in the statement of basis and purpose states a pattern of violation is a history of violations of the act, commission rules, orders, and or permits that demonstrate an operator's disregard for those legal requirements. And enforcement guidance and penalty policy states a pattern of violence is a history of noncompliance with the act, commission rules, orders, or permits. It demonstrates the operator's persistent and potentially intentional disregard for these legal requirements or the commission's authority. In this instance, I do believe that this operator has committed a pattern of violation. I need to look no further than the recently adjudicated and confirmed NOAVs that we heard in August to make this determination, though I chose to look further at further confirmed and adjudicated AOCs or OFEs to further bolster this determination. After 5 days of hearings, testimony, and statements, we found KPK violated 22 different rules. Of particular relevance to my patterns of violation determination are rules 324 big A little a, 906B, 901C, and 907A. While in this particular hearing, we have confirmed violations of 324 big A little a twice, once in docket number 2011-00261 and once in docket number 2011-00262. There was a previous violation of this rule in order number 1V181, making a total of 3 violations. As for 906B, we have 2 violations that have been confirmed at this hearing, one in docket number 201-200-274 and one in docket number 210-200-010, as well as 2 previous violations in order 1V725 and 1V728, making a total of 4. For Rule 901C, we need only to look at the current hearing where we have 4 confirmed violations occurring in dockets 210-200-010, 210-200-010. Oh, I pasted the wrong ones in there, but in the 3 docket numbers in the existing NOAVs. And finally, for Rule 907A, we have 3 instances of confirmed violations in this current hearing in dockets 210-200-10, 2011-00261, and 2011-00262. It is this evidence that I utilized to determine that indeed the operator did engage in a pattern of violations. Note that I did not use any evidence or testimony associated with the 901A order in my determination, but chose to utilize only confirmed and adjudicated NOAVs and orders in my findings. Thank you for letting me be long-winded there.
Okay, thank you. I am just FYI, I usually attend via my PC as well as the hearing room. My PC just decided it needed to restart, so I'm only attending via the hearing room, but I still think you can all hear me. So with that, who would like to speak next? I'm not going to, since my notes are no longer before me. Go ahead, Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Commissioner Messner. I appreciate that you itemized everything out and read through the different pieces of the rules and the act, the rule, and the enforcement guidance and SBP. I won't reread all of those things, but I will just note that in particular, the enforcement guidance was influential to me with respect to the line stating that it that a pattern of violations demonstrates the operator's persistent and potentially intentional disregard for these legal requirements or the Commission's authority. And while I don't necessarily believe that we have evidence that it was potentially intentional, I think there was persistent disregard for the Commission's authority in multiple occasions. I also believe that there were several instances within the NOAVs that we considered in August that consolidated violations and put a lot of, made a lot of concessions with respect to those NOAVs along the way. And so potentially with the counts that you have that Commissioner Messner itemized, I had a couple more if you count kind of the individual violations within a particular rule. But I think there would be even more if we went back through and looked at, what was consolidated in the process. So I also believe that there was a pattern of violations. And I also looked at the fact that there were several instances of what appeared to be disregard or just ignoring inspection-related deadlines and projects that just have remained languishing. So I also find that there is a pattern of violations here.
Thank you, Commissioner Najapa. Commissioner Gonzalez?
Thank you, Mr. Chair. So I'll start at the end, of course. I think that I found also there's a pattern of violations, and I'm going to walk through my thought process on that because I think I hit on a couple different points that my other two commissioners that have deliberated thus far have hit on. So I just want to share that. One of the main questions that I wrestled with is when does a repeated action or inaction become a pattern? In the testimony that we've had that's been associated with the NOAVs that are subject to this hearing, I've heard what seems like the same story over and over again. An inspection occurred, a corrective action was ordered, a corrective action was ignored or not acted upon, a subsequent inspection occurred, and then there was either repeated or updated corrective actions that were ordered, and then corrective action was taken. Right. So regardless of what the rule was, that's what I heard kind of over and over again. That was the same story, to the point where I was confused as to what NOAV I was hearing at the time. And so to me, this indicates a pattern of the agency having to ask multiple times for KPK to file the necessary forms, or for KPK to install the necessary BMPs, or for KPK to issue the necessary notices under our rules. And also thinking about in this pattern of violations question is how far back do we need to look to identify a pattern? In the last 20 years prior to the 7 NOAVs at issue here or issue at this hearing, KPK was issued 8 total orders finding violation and assessed penalties of a little over $200,000. I think $207,000 was the number. And so I'm kind of considering, at what point does a pattern become a pattern, and how far back do we need to look? I'm considering this question in terms of, is this pattern of violation being determined on the basis of recency or the consolidation of these NOAVs, which are subject to this hearing? On the other hand, if we go far enough back, does a pattern of violation determination that's based on all of an operator's violations over their history, over that long-term period, does that dilute the ability to find a pattern within a recent string of violations? And so this is something that I wrestle with a little bit. And I think the conclusion that I landed on was that, as to the action over the last 2 years that we've dealt with over the last month in this hearing, that there's a pattern and it's clear. And if we look back further, I don't know that I would arrive at the same conclusion. But I don't think that's that important, because I think that, what I believe is that even recent history can be enough to establish a history of noncompliance. And while all these violations were not the same, or all these rules that were being violated were not the same, there's a thematic pattern of disregard for rules and for agency orders to take corrective actions, to submit the mandated forms or to make the necessary notices, despite corrective actions being ordered. And given all that, I think that where I land is I am finding a pattern of violation as to KPK's actions and inactions that resulted in the violations that are before us in this matter.
Thank you, Commissioner Gonzalez. Commissioner McGowan, do you want to go next, or do we want me to?
I'll go.
Okay.
I think I'm aligned with everything that the commissioners have said thus far. And I think I took the perspective that Commissioner Gonzalez did, which was, how far back do we go to look for a pattern of violations? I think that there's going to be an expectation, because some operators own many wells. They have many different operations and locations. I don't expect perfection, but I think there is an expectation of competence and compliance with the rules. And so I started with the 7 NOAVs alone, and thought that there was a show of pattern of violations and a history of noncompliance with the Commission's act and rules over the past several years. I don't think that we have to keep looking at one particular rule over and over. I think 525 is broader than that and says a pattern of violations with the act itself and or all of our rules. And so while I appreciated that staff said, 2 violations of 324AA or 3 violations of 901C, I also looked at other patterns, such as the inspection reports of those that supported the NOAVs and the repeated corrective actions that were either neglected or ignored, and many requests by staff for this operator to take action, repeated requests for compliance and it just wasn't there. And so in addition to the rules, I looked at what was going on with corrective actions. I did also look at what was going on with our sister regulatory agency, the consent decree with CDPHE and EPA. I think that also is indicative of some enforcement issues and compliance issues with this operator. And I agree with Commissioner Nanjapa that there seems to be this persistent and potentially intentional disregard. In many instances, it felt to me that the operator was asking for forgiveness, just doing it and then seeing what happened and asking for forgiveness later after they did or did not do something. And I think we're probably going to maybe get to the discussion of knowing or willful later on. So I will hold my comments on that piece for later.
Thank you, Commissioner McGowan. Yeah, I echo what I've heard from my fellow commissioners. I too find a pattern of violation. I want the record to reflect that I did not consider the 901A matters at all. I considered mostly the most recent violations that were in the 7 NOAVs that we looked at. And I just, just some additional context around this. I agree with Commissioner Gonzalez's categorization, a thematic pattern of disregard for rules. And I also note that in cross with both Chair Kaufman and CEO Kaufman, they both somewhat admitted that this action or this thing that we're doing here established that they admit that there was a disregard for legal requirements. I think just like looking at one matter in particular can kind of put some perspective on this, and that's the soil spread field. They made their own determination that soil was uncontaminated and dumped the soil and dumped it behind their office. And had we not learned of this, I think through a third party, that would have happened and we would never have known about it. That's not caring for compliance, and it's a failure to basically undertake a phone call to staff. Frankly, had Kevin Kaufman been in charge, maybe a phone call would have occurred, but his staff did not act this way. And I find over and over again, this sort of what I call kind of a conscious disregard for ensuring compliance with the act. And our rules are set up to require a thoughtfulness and a carefulness in the operations of oil and gas. And through these violations in the past AOCs, there was a lack of care and thoughtfulness in actual operations. I don't know that I find intent, but I just find a conscious disregard to ensure compliance with the act. And that's not how this is set up. And I think we heard quite a bit from staff that operators need to comply with the act and follow the rule forms and have that dialogue. And that's where I sort of find that there was indeed a pattern of violations. So with that, does anybody have further comments, thoughts around the pattern of violations issue? I think we've unanimously made this preliminary finding of pattern of violations having been met. And I'm not seeing further dialogue from commissioners around that. I think the next step perhaps would be to go, since we're not going to talk about certificate of clearance or the pulling of new permits at this time, but to go NOAV by NOAV and determine whether the pattern of violation findings, whether there should be an increased penalty for violations, for individual violations, and if so, by what amount. And I would suggest we perhaps go through the five matters that I was involved in, and then I'll go have a nice break and y'all can go through the other two, I believe, because I think one was pulled, and then we could reconvene and talk about next steps, that is ability to pay, compliance plan, all of that, and whether we go sort of a special master route or otherwise. Does that work for you guys, my fellow judges, Commissioner McGowan?
Yes, that works for me, Mr. Chair. I did have a couple of questions about things that have been brought up or not brought up that I would like to talk about or have considered, and I'm not sure where they belong and at what point. So for example, I'm intrigued by the idea of an escrow account. I think I'd like to talk about potential increased financial assurance for some of these sites. And I'm interested in potentially also talking about looking at putting a hold on any transfers or KPK taking on additional operations until they can kind of right their ship. And I might be the only person who wants to talk about these things, but I don't know where we should talk about those things as part of our overall.
Yeah, I don't know that there's a right or wrong answer to any of this, Commissioner McGowan. I'm sort of thinking we might want to go NOAV by NOAV and think about aggravating factors. And then, because I think some of those, I think the things you just identified go into that bucket of sort of compliance plan. What are, so if we were to go down the idea of special master, I just get why I don't think we can finish all that up today. But what I would like to do is give each of you an opportunity to provide your perspective as to the things that you think would be important for that discussion when that discussion takes place. And so I at least think maybe that's after we go through the NOAVs, but I could be convinced otherwise. Anybody else? Okay, so I think the thing to do now would be to go through the NOAV by NOAV. And AG Davenport, Commissioner, Ms. Larson, should we pull up some documents so that we can know what we're looking at with regard to the fines that have already been assessed per NOAV, starting with the first one that I was on? And then we can discuss amongst ourselves whether and to what extent we believe that the pattern of violations should result in a aggravating penalty.
Mr. Chair, I'm prepared to pull up the claims tables that the commission previously reviewed to guide that discussion, if that's the commission's pleasure.
That would be fine by me.
Okay. If memory serves, if we're kind of going in the order that the commission heard presentations from the parties, I believe the first one would be the NESU #1 NOAV, but I'm happy to pull up things in any order that the commission desires.
I think it's fine as long as we're going through the ones that I was involved with. And Ms. Amaro, is there some reason that Karen is pasted into the main window here?
She was the last one to speak.
Okay. You were just very big on my screen. So now we can see everything.
You're welcome.
That's good. Commissioner Messner, go ahead.
Thank you, Mr. Chair. Just a question. I mean, I think there's going to be a couple of different approaches here. I'm not sure where the other commissioners are, but I don't know if some commissioners are interested in looking at potentially applying a pattern of violations aggregating factor to every single line item, or whether we're looking at just the violations that staff is asking for an increase in violations. Or I guess I'm just curious about that. And maybe we can just do it as we go through, but
yeah. Thank you, Commissioner Messner. I too created a little spreadsheet that identifies the various violations and the pattern of violations aggregate that staff suggested that we take a look at. For instance, the NESU #1, I do not believe staff asked for a pattern of violation aggregate on that one. That's I think how you and I did this over the lunch break, Mr. Davenport. We could also have a discussion about, do you want to just look at the The one staff suggested that, I think it's 7. 1, 2, 3, 4, 5, 6, 7. No, wait, 1, 2, 3, 4, 5, 6, 7, 8. Yeah, 8 total penalty, pattern of violations, aggregations. And we could just speak about it, as a whole. And do you agree with that? And if so, what's the percentage? I think we probably would need to do the ones that I was not involved with first, and then you guys could do the ones that you were involved with. So I think there's any number of ways that we can do this, and I don't know what folks are thinking, but Commissioner Messner would like to tell us what he's thinking.
I always like to tell you what I'm thinking, but so at least for me, I'm gonna look for a 20% increase in penalties associated with any rule violation of 324 big A, little a, 906B, 901C, 907A. I don't agree with the staff's determination that only the second chronological instance of 901C or 907A are warranted, but I do believe that they should be applied to all. So that's generally speaking how I was approaching it.
Commissioner Gonzalez?
Thank you, Chair. And I appreciate Commissioner Messner's kind of diving in to try and keep us going in the right direction. I don't know that going NOAV by NOAV, for me at least, is necessary. I have a pretty general comment.
Can I do this?
Yes.
Let's ensure that the discussion that we're taking place, since it's a little more collective, does not involve Grant Tank or Charter Schneider. So right now we're going to be talking, since we're talking sort of globally, about the 5 that I was involved with. I just want to make sure we are clean on that front. Is that okay?
That's fine. In that case, I've got a question for AAG Davenport. I have kind of one sweeping idea on what I'm thinking here for imposition of penalties, which would obviously implicate all the NOAVs that are at issue here. Is that appropriate for me to make a general comment in that regard as to where I stand, or should I go and wait for the NOAVs by NOAVs and kind of assert that then?
Thank you, Commissioner Gonzalez. I think it is appropriate to the extent that you're commenting on making a general comment in regard to the 5 NOAVs, which the chair participated in, and I think recognizing that the conclusion may be the same for the other 2 as well, but
in that case, Mr. Davenport, I'll just go ahead and participate when the NOAVs pop up. So,
okay.
Okay, so AAG Davenport.
And I think, if I may,
go ahead.
Chair,
Mm-hmm.
I recognize that we've got a couple commissioners who have made some generalizations. I think given the distinction between NOAVs in regard to the chair's participation or not, it may make some sense, even if your thoughts are similar in regard to violations, to still just somewhat, and it can be hopefully an efficient discussion, somewhat talk about it on an NOAV by NOAV basis. And after the first one, I think you could simply say my comments are the same as the last one.
Okay, let's do that. We're just trying to be careful with regard to the recusal. So why don't we do that? Let's take up the NESU consolidated. And if AAG Davenport, if you could share your screen on that. And then I'm going to call upon Commissioner Messner to provide his comments relevant to that one, knowing that they may be similar in other ones.
Mr. Chair, may I make a suggestion?
Go ahead.
So I did note that in staff's pre-hearing statement, they did not apply pattern of violations to either of the alleged violations in the NESU number 1 flow line. However, I acknowledge Commissioner Messner's comment that he did not necessarily agree with staff's choice not to apply pattern of violations to the first instance. And I think that may have been why in the 901C staff did not allege a pattern of violations. So I might suggest we start with NESU number 1 to acknowledge Commissioner Messner's.
Let's start with NESU number 1. Thank you.
One moment, please.
To our 93 participants, this is the way we go about figuring out the sausage making here, so bear with. Okay, A.G. Davenport is sharing a screen. You might want to
Yeah.
make it a little less big.
I will try to do that.
There you go. Perfect.
And commissioners, I do want to point out one thing. I have accepted, it got pretty busy, I thought, with if we kept the red lines in. So I've accepted the red lines you made during deliberations on the hearing on the NOAVs here. These reflect your decisions, and rename this table as the final penalty calculation commissioner deliberations.
So A.G. Davenport, let me ask that in a different manner. This is what we were arrived at. Is that
This
right?
is your decision.
Okay, great. I'm going to just pick up on Commissioner Messner to go first.
Thank you, Mr. Chair. In this particular instance, my recommendation would be a 20% aggregating pattern of violations factor added to both 901C and 907A.
Commissioner Gonzalez, can I pick on you second?
Sure can. So in regards to this NOAV, I'm not inclined to issue an additional aggravating factor penalty. I think the penalties that have been imposed already for the associated NOAVs are appropriate to penalize the operator for the violations at issue. I will withhold additional comments on other remedies and my thoughts on the ability to pay for that section of deliberations.
Thank you, Commissioner Gonzalez. Commissioner Nanjapa, I'm just going to roll through it this way, if that's okay.
Sure. Thank you, Mr. Chair. I kind of took a slightly different tact. I think I felt that for the pattern of violations with 901C, that a 10% increase on the requested penalty there should be applied. And given the concession that we made in our calculation on the 907A with respect to the additional remediation that had been done, I am comfortable with leaving that one as is.
Okay, Ms. Larson, are you keeping track? So maybe what we'll do is we'll share your screen once we hear from everybody.
Okay.
Commissioner McGowan?
Thank you, Mr. Chair. And I think I took an even slightly different slice of the apple or bite at the apple. And I thought that what staff was requesting was the consideration of additional penalties for pattern of violation for specific rules. And maybe I was misinterpreting what staff was asking for. So I was looking at additional penalties potentially for 324AA, 901C, 906B, and 907A. And so in this case, 901C and the 907A were both requested by staff. And so I think it's appropriate for us to look at some sort of additional penalty based on pattern of violation. It's unclear to me how we come up with a 20% or the 10% other than, historically maybe what staff has applied. And I'm inclined to, I think I'm a little more aligned with Commissioner Nanjapa in that a 10% penalty seems appropriate, but I would apply them to both because those were both identified as rules for patterns of violation by staff, and I agreed with their assessment.
Okay, thank you, Commissioner McGowan. I too agree a 10% on both. So Ms. Larson, if you could share your screen and then we can see how far apart we all are, or if we've got at least 3 people thinking the same lines, then we can see if we've got a finalization on this front. Give Ms. Larson a second, guys.
Yeah, thank you. I apologize. I was working the sheet I'm keeping track on is on another computer that I'm not logged in on Zoom. So I'm just waiting for.
Oh, you had to email it to yourself.
I had to email it to myself. So
Commissioner Messner, go ahead.
Thanks, Mr. Chair. This will give Ms. Larson a little bit of a chance, but I just wanted to deliberate on this just a little bit more.
Yeah.
And just make a few points. Number one is that the 20% associated with pattern of violation is longstanding commission practice. Staff will look at what we determine here and apply it in the future to negotiated AOCs. And so I think it is important that we stay consistent with what staff has typically done for negotiated AOCs around patterns of violation. And so that's where I came up with 20%. I will also note that the Act does allow us to go up to as high as $15,000 per day of violation, and that this 20% increase on 100,000 is 20,000 total, versus what potentially could be millions of dollars of increased violations associated with the aggregating factor of pattern of violations. And so I don't think that the 20% that would be applied, particularly in this instance, is a significant amount. And so I also think it's important to understand the historical context of this.
Thank you, Commissioner Messner, for those thoughtful comments as to justification. Commissioner Nanjapa.
Thank you, Mr. Chair. And yeah, thank you, Commissioner Messner. I also kind of looked at that in Enforcement Manager Farron's, Enforcement Supervisor Jeremy Farron's testimony. He did note that with the Sandridge instance, which was the most recent, that was a 10% increase. And so it sounded like there was a lot of discretion that was applied case by case. For me personally, as I think about these violations as individual violations, the 901C, I think we classed it appropriately as a class 2 moderate. And given that, I think it is slightly different than an E&P waste storage or management situation or something with a more direct environmental impact. And so that was my thought process in thinking of a 10%. And so I'll just say, as we go forward for the 901Cs, I'm thinking of a 10%, but I do have particular instances where I feel the other violations in question may need to be different. So I'll just say that.
Commissioner McGowan? This is giving you tons of time to get ready, Ms. Larson.
And I'm ready for whenever you'd like it.
Thank you, Mr. Chair. So I think something else that I've been thinking about is, the economic benefit in some instances. And I know we're not on the soil spread field, but I feel like we kind of discussed those pieces during the penalty setting, and some of the penalties felt appropriate to me and addressed kind of offsetting any kind of benefit the operator would have had. I think we should consider for some of these others, to Commissioner Nanjapa's point, kind of the gravity factors, actual or potential harm that occurred, the importance of the regulation and or the responsiveness of the operator. And so I think that all of those things for me, the size of the violation, the amount of pollution, et cetera, are all things that we should also consider when we're figuring out the additional penalty for pattern of violation. And so I see what you're saying, Commissioner Messner, and I'm not sure that there's a perfect way to do this. But I think that the precedent we're setting is that there should be a penalty for patterns of violations, and the commission will consider them on a case-by-case basis. And that I don't think that if we choose 10 or 20 or 50 or 100, that we're going to set precedents for everything that follows. I think we're going to hopefully look at these cases as they come to us, and some will be perhaps even more grave or less grave, and we'll make those decisions on what the additional amount should be.
Thank you, Commissioner McGowan. Ms. Larson, do you want to share your screen?
Yes. Let me know if I need to make that larger or smaller. Happy to do so.
I think that's good. Okay, on the 901C, I think and again, I'm not trying to put words in anybody's mouth, and I'm just trying to keep this moving forward, right? So I do see 3 consistent positions, Robbins, McGowan, and Nanjapa at 10%. And then on the 907A, we've got no additional penalties twice, and then I've got additional penalties 3 times, and there's inconsistency in the numbers. What do we want to do? Okay, I'm going to ask Ms. Commissioner Nanjapa, what's the basis for no additional penalty on that one? I know you said it, but.
In my view, this was one where they were taking additional remediation action, you know, for historic contamination and, you know, doing more kind of than, they were spending a lot of their own capital to get this remediation underway. And if I understood correctly, based on the latest report here, we've that is now closed, if I recall correctly. And so I sort of was thinking that, you know, it was a sufficiently high penalty. We gave them a little bit of a concession with the additional work that they were doing. And so I didn't feel that this particular one rose to that level of needing an additional penalty.
Okay. In order to keep us moving forward, I can embrace that logic and move my vote to no additional penalty, which then gets us to 3 votes that are consistent. And again, I'm not trying to do this or undo this. I'm just trying to keep us moving forward. Are we okay with that? And then we won't have to, you know, we can then move on to the next one. Okay. So we now have covered NESU number 1. Let's now speak to, go ahead,
Okay,
AG Davenport.
I'm sorry. I apologize, Mr. Chair. So then we're doing a 10% on the 901C
Right.
increase. All right. Okay, thank you.
Oh, if you could share your screen, Mr. Davenport, on the NESU consolidated, we'll go to that one next.
Yep. Okay, one moment, please.
Okay, do you just want to go in the same order, Commissioner Messner?
I'll try to do it so we don't have to keep switching back and forth.
Thank you, Mr. Chair. Like I indicated at the beginning, I'm going to be consistent at 20% for any 324, 906B, 901C, or 907A.
Okay. Commissioner Gonzalez?
Yeah, I'm consistent as well. Again, I believe that the penalties we've already imposed for the associate NOAVs are appropriate. And I think that for me as one commissioner, I think that there are other levers that we can pull and other remedies that are better suited for where we're going to land on this for the penalty of violations. So,
Commissioner Messner?
Thank you, Mr. Chair. Yeah, I appreciate that, Commissioner Gonzalez, because in the scheme of what I'm looking at, some of this determination would have come during the discussion around compliance. But my numbers associated with looking at what potential reductions could occur through compliance are going to be affected by the determination of the ultimate penalties here. And so that's these 2 things play together. And so I think it's important just to understand that at least in my scheme, I did anticipate looking at a potential reduction associated with compliance, but or a suspension. But yeah.
Okay, and I appreciate that. I will tend to agree on that front. Commissioner Nanjapa?
I will remain consistent on particularly 901C and would look for a 10% increase. I also am thinking about this in terms of how we think of the larger picture and what kinds of opportunities there might be, or levers to pull, as Commissioner Gonzalez put it.
Oh, you're muted, Commissioner Nanjapa.
I am? Oh.
Oh,
No?
it was us. Sorry, that's
Okay.
our hearing room acting up again. Sorry.
Okay. I think, again, for me, I thought about this with respect to the documentation. I think it's very important and feel like we classed it correctly and put the daily penalty rate correctly. But for the pattern of violation for 901C, I'm going to put them all at 10%.
Commissioner McGowan?
I agree with Commissioner Nanjapa. And to the point of levers and tools, I think this is a tool this is just one tool, and I know that it will be part of a larger discussion, Commissioner Gonzalez, when we get to the end and we start thinking about all these other things that have been brought up as part of resolving these issues.
Okay, I was influenced by staff and took a look at the ones that they wanted us to provide an aggravating factor. Theirs was 20%. So I would actually, so on the last one, staff did not ask for an aggravating factor. On this one, they did. And so I would honor the 20%. So we're at 2-2. Not sure what we want to do with that. Is any of the 10%ers thinking they might go to 20, or any of the 20%ers thinking they might go to 10, or do you want to cut the baby and go to 15? Go ahead, Commissioner Nanjapa.
I'll let Commissioner McGowan split babies, but I will. I can go up to 20% on this one. I'm just realizing and looking in my notes that this was the instance where there had been some difficulty with just kind of reaching agreement on what needs to happen next. And so I think that creates that additional gravity, I guess, in this situation. So I'll go up to 20% on this one.
Okay, with that, we have 3 consistent votes. AG Davenport, I appreciate your capturing this on one document. And Hearings Manager Larson, I'm sure you're capturing this as well, so that we'll have something to come back to. Okay, do we need to move to, I don't know if I have these in order, but on my list, I have the UPPR Pan Am next.
Yes.
And that had 5 violations, and staff had requested 2 pattern of violations aggregate increase at 20%, just so I can set the floor. Commissioner Messner?
20%.
Commissioner Gonzalez?
No additional penalty.
Commissioner Nanjapa?
On this one for 906A and 907A, and sorry, 324AA and 907A, I would do 20%.
Commissioner McGowan?
Agreed. This was a really complicated one with lots of pieces, but I think what's a prime example of pattern of violations and inability to kind of I'll stop there.
Go ahead.
Thank you, Mr. Chair. Commissioners, I apologize. I was in the middle of pulling things up. I understood Commissioner Messner and Commissioner Gonzalez. Commissioner Nanjapa, I think for 906A, you suggested 20%.
No, I'm sorry. I meant 907A and 324AA, which are the violations that have been raised in particular by staff.
Okay. Commissioners, I do have to raise something. The commission consolidated 324A with other violations, so did not assess a penalty for the specific 324A violation.
Good point. So we really are not in a place to do an aggravating factor on 324AA since we didn't do an initial factor, whether that was intended or not. I don't know that we know. So it really becomes just the 907A matter. And I believe we have 4 of us that are at 20%. I never had a chance to say, but I was at 20% as well. That's what staff asked for. So commissioners, are we comfortable then that it's 20% on the 907A for the UPPR Pan Am? Thumbs up. And Bill, knowing that you're not there, which is fine. Okay.
Mr. Chair, if I may, I apologize for interrupting. Commissioner McGowan, were you also in support of 20% just for my notes?
Yeah, she was. Okay, I'm going to slow us down a little bit. I think we're overtaxing our hearings manager and our AAG with regard to the work they're doing and sharing screens. So let's give AAG Davenport a chance to catch up.
I believe I've caught up on this particular matter as long as the commissioners agree that it accurately is reflecting.
Yeah, that's a 4-1 vote for 20%.
Okay.
Okay. So the next one that I had on my list, again, going in no particular order, was soil spread field. And there were 4 violations that we found, and staff had asked for 2 violations to have a 20% adjustment, if my notes are correct. And that's the 907A and the 324 big A little a, I believe. Let's let Kyle catch up.
I'm ready.
Okay, you're still on Zoom. There you go. Okay, good.
I'm just being
Okay, Commissioner Messner.
Thank you, Mr. Chair. I'm at 20% for 324AA and 907A.
Commissioner Gonzalez.
Yeah, I'm going to stick to kind of where I've been, but I do want to recognize that of the NOAVs that we heard, this is one of the most blatant disregards for commission orders, for commission rules, and for corrective actions that we saw there, and I think that it was definitely a very poor choice of decisions by KPK in ignoring not what was part of the permit and what was also part of corrective actions. So I do want to set that out there. That being said, I do believe the penalties that have already been imposed and assessed are appropriate, and therefore I am not inclined to issue an additional aggravating penalty for pattern of violations for this particular rule.
Thank you, Commissioner Gonzalez. Commissioner Nanjapa.
Thank you, Mr. Chair. Thank you, Commissioner Gonzalez. I was going to say the same. For me, this one is particularly egregious and highly disturbing, and definitely 20% on both 324AA and 907A for me.
Commissioner McGowan.
I agree with what has been said thus far, and I guess I would tie on to this that I think that I believe that this was done also for economic benefit. And I think that that's another aggravating factor to be considered as part of the pattern of violation.
And I agree with all the things my fellow commissioners have stated, including Commissioner Gonzalez, and I'm at 20% as well. And I note that staff was at 20%. So I believe that is 4-1 at 20% for the 324 big A little a and the 907A. Kyle's even got a calculator out. So let's let him catch up.
Does McAllen want to add anything for economic?
I believe we'll take up the Gilson next. We found one violation. Staff has asked that that one violation have a pattern of violations aggregate of 20%. Let's give AG Davenport a chance to pull that up. Okay, Commissioner Messner,
Mr. Chair, 20%.
Commissioner Gonzalez,
No additional penalty.
Commissioner Nanjapa,
20%.
Commissioner McGowan,
1%.
and 20%. So that's 4-1, 20% aggregate increase. And with that, you've got Grant Tank and Charter Schneider to finish up. And I am going to continue with my recusal, and I will leave the room and would ask one of you to chair for the next two, and then have, maybe after you do the next two, let's take an afternoon break, and then Kyle can come get me, and then we can get started again on additional deliberations.
One moment, commissioners, do you have a preference on which NOAV you'd like to take up first between the Grant Take Battery and Charter Schneider? I apologize. Could we start with who is going to be chairing this little portion of the hearing?
I'm glad to do it to stay consistent if everyone's okay with that. I don't think there's gonna be much chairing in this. That being said, Mr. Davenport, would you please walk us through our spreadsheet and our two next NOAVs?
Sure. I'm just going to select Grant Take Battery and should be sharing momentarily.
AG Davenport, your microphone, I'm not sure if you have your near
Yep,
one on.
thank you. I have just randomly selected the Grant Take Battery.
Okay, we'll go in the same order as we've been going. So I will turn to Commissioner Messner first.
Mr. Chair, I've got 20% on 906B.
Thank you, Commissioner Messner. I am not inclined to add any additional penalties. Commissioner Nanjapa.
In this particular instance, I am inclined not to add additional penalties simply because of the ongoing work and remediation and the desire to get this completed and finished.
Thank you, Commissioner Nanjapa. Commissioner McGowan.
Thank you, Mr. Chair. For me, this was 10%, understanding that they are trying to remediate, but I believe this is the one where it was unclear to me that this was indeed historic versus KPK ownership over a long period of time. And I thought that that was something that influenced for me as a factor.
Okay. Thank you, Commissioner McGowan. This looks like it puts us at yet another impasse in terms of not having consensus. Do we have any movement?
Mr. Chair, I mean, I would be willing to go down to 10% versus nothing on this one, because I do think that it is very unclear whether this is a historic spill, but could very well be this particular operator's historic spill. So,
thank you, Commissioner Messner. I appreciate the give there.
Mr. Chair, this is a tough one. I'll just say, because I agree with the rationale, with respect to the fact that this is ongoing, the remediation continues, there's been a lot of resources put into it. But also there is the potential that this is a matter of their own doing. And so I also want to just note again that I'm still thinking of these with respect to impacts, and also thinking about the overall situation that we'll get to a little bit later on with respect to other levers we can pull. But given all of that, I can go up to 10% as well.
All right, Commissioner Nanjapa, thank you for that. Sounds like we will have a 3-to-1 at 10% there. This grant tank battery one was an interesting one, given the work, the reason for instigating the work, what they found along the way, and the preceding testing. So I appreciate all the thoughtful consideration there. All right, Mr. Davenport, are we ready to move on to the next one?
Yes, one moment, please. The last one is Charter Schneider, which has a number of violations, so I may need a minute to appropriately adjust the size or view. All right, commissioners, I'm ready for you.
Thank you, Mr. Davenport. For the Charter Schneider tank battery, Commissioner Messner.
Thank you, Mr. Chair. I'm at 20% for 901C. I think there's 7 of them, right? So yeah, 901C.
20% for the 2 901C violations for Commissioner Messner.
That's correct.
Again, I'm not inclined to add additional aggravating factor penalties on this, and I'll discuss that later as we get to the next step of our deliberations. Commissioner Nanjapa?
I am going to stay consistent with the 901Cs generally at 10% for both of the 901C violations here.
Commissioner McGowan?
Thank you, Mr. Chair. For some reason, I thought that this was another one of our consolidated ones, but I might be mixing things up. But I agree, I'm at 10% on this one.
I think in this one we consolidated 2 other rule violations, and I think that there were potentially a number of 901C violation like stages along the way that may have occurred. So I think you're right there. We have 2 votes for 10%, 1 for 20%, 1 for 0. Mr. Davenport, does that give us a majority at that? Do we need further deliberations to reach more consensus there?
Chair, yes. The standard practice of the commission is a tie is a failure, though we're not exactly, that's the best guidance I can give you is on a vote with an even number of commissioners, a tie would be considered a failure of the motion. So if we consider this a motion, we need 3 commissioners to get somewhere.
Thank you for that, Mr. Davenport. Yes, this is not a pass-fail question. And so in that case, do any other commissioners wish to amend their recommendation?
Mr. Chair, I've gone down. I think it's your turn to go up.
I think that's a fair comment, Commissioner Messner. I was thinking about that in the last instance. I do not feel like there should be an increased penalty. I think that our penalties were appropriate to begin with. I believe on many of these I advocated for a lower penalty based on our discretion during the hearings. I stand by that. I think that the total penalty that we're going to end up with, regardless of whatever suspensions or reductions occur in the next stage of deliberations, can occur. I'm not willing to advocate for an additional penalty, but I suppose in the effort to move this along, I would be willing to acknowledge the 10% penalty that has been proposed by Commissioner McGowan and Commissioner Nanjapa, and I will move in that direction. So 10% for me for both of these.
One moment, commissioners. And while I'm doing this, I'm going to suggest that the this makeup of the commission actually vote in favor of it. In my view, what you've reached is a final conclusion on the penalty amount for both of these NOAVs. And we did not vote for the previous 5. Commissioner Robbins vacated before we had a chance to, but we can do that when he comes back. So to avoid any confusion, I do recommend a motion and vote setting the final penalty amount for the NOAVs in the Charter Schneider and Grant Take Battery NOAVs.
Do we need to acknowledge a total penalty amount, Mr. Davenport, or just a penalty amount based on the rule violations as identified here on your spreadsheet?
You can move to vote in favor of the final penalties for those 2 NOAVs as reflected on the spreadsheets amended by your deliberations today.
I hereby encourage a motion.
So moved.
Second.
All those in favor?
Aye.
Aye.
Aye. Looks like motion carries.
Thank you, commissioners. Thank you, commissioners. I believe Commissioner Robbins' request is that we take a break, and so I can go get him and bring him back. Mr. Chair, what's your pleasure on how long of a break? Commissioners, what's your pleasure on how long of a break you'd like to take?
15 minutes sound good to everybody? 3:26 then.
Thank you.
Okay, welcome back, folks. Good to see you. AG Davenport indicated to me during the break that you took final action on the 2 penalty calculations for the 2 that I was not involved with. And AG Davenport would look to you, but perhaps we need to do the same on the 5 that we've now finished up so that we've got the total penalty sort of resolved and we know where we're at on that front.
Yes, Chair, I recommend a motion to approve the final penalty amount as reflected in the Commission's deliberations today for the NESU number 1, NESU Consolidated, UPR 43 Pan Am, Soil Spread Field, and Gilson NOAVs.
Do we have a motion?
So moved.
Do we have a second? Any discussion on the motion? Okay, seeing none, all those in favor of the motion signify by saying aye.
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 Any opposed? Okay, motion carries. Okay, so we now have gotten through the pattern of violations, and we've gotten through NOAV by NOAV with regard to consideration of increased penalty. At this point, I sort of reiterate where I was earlier, which is that due to a number of different things, I sort of think that we're not in a place to finalize deliberations on corrective actions. And that reason there is we just recently received both staff and KPK's thoughts about corrective actions that are needed. And we need to look at both of those. And then also, I believe I'd like to at least give staff the opportunity to do further inspection. Their corrective action list was based upon things they had received from KPK. And I think perhaps that may or may not need to be done. I don't think we're in a place to finish up the compliance plan because we just received from staff their proposed compliance plan. KPK has not had a chance to review that. It involves a lot of different things, such as identification of third-party consultants. And then it involves some of the other things that at least Commissioner McGowan pointed out, like the concept of an escrow concept of increased financial assurance, hold on transfers, et cetera. I think what I'd like to hear from folks is, would you be okay if we were to follow my suggestion, which is let's put these guys in a room, but let's not let them be in a room alone, but instead allow me to be in that room as sort of special master counsel, whatever we want to call it. But before we do that, I'd like to get further dialogue from, well, first off, are you okay with that? And then secondly, I want to give each of you an opportunity to provide some perspective of what you would like to see in either the corrective actions or the compliance plan. And then my last component to this is, I don't necessarily think we need to do that piece of it, providing instructions today. If you wanted to take a break now and we could continue this hearing to tomorrow's hearing, and then we could give all of us a chance to look and see what are the things we think are important for discussion in that sort of smaller setting. So first, let's hear from everybody about this approach of trying to move into next steps. Anybody want to go first? Commissioner Gonzalez.
So, Mr. Chair, I appreciate the suggestion. I think it's a good idea to get these folks in a room and to work out what may be a compliance plan and a plan for corrective actions and timing associated with that. I'm curious if we have to delay all of our deliberations until that is complete, or if we could generally agree on kind of where we're at and then send it back for, hey, this is where we're going to end up, and you're going to have a compliance plan. What that looks like is to be determined by the parties with a special master, as you've called it, to come back and report to us on that in a specific time frame. Like, can we move forward with everything else and then just say, hey, there's going to be something that you guys are going to have to do, and you're going to report back on that, and along with your other suggestions.
I think we can do that. Commissioner Messner, you raised your hand. Do you have additional thoughts?
Thank you, Mr. Chair. I generally agree with Commissioner Gonzalez. I do think that we want to provide our thoughts here today. At least I do. I'm not sure my thoughts will change much from today to tomorrow. And I do think creating some bookends, understanding that should we choose to go with a compliance plan, we're providing a compliance plan, and there should be some opportunity from input from other parties, but ultimately it is this commission that is determining that compliance plan. And I think we need to make sure that we continue to have that authority to determine the appropriateness of the compliance plan. In addition, I think a compliance plan potentially comes with concepts around suspension of penalties or not. And I think that would be something good to discuss here today, whether that's an appropriate thing or an inappropriate thing to be able to insert into any conversation around a compliance plan.
Okay. Yeah, give me just a second. Thoughts, Commissioner McGowan, Commissioner Nanjapa, Commissioner McGowan?
Thank you, Mr. Chair. Yeah, I would, I definitely think that I would like to give some input into what I would like to see in some sort of compliance plan, components for them. I also have some ideas about, just based on kind of the frustration that I'm sensing with staff, that potentially the reporting should come to the commission on how progress is being made. So I just think that maybe there's some things we'd all like to talk about as far as what we'd like to see as part of a compliance plan that comes back to the commission for discussion and approval.
Okay. Commissioner Nanjapa?
Yeah, thank you, Mr. Chair. And I agree with the various comments that have been raised here. I think there's a few things we can discuss with respect to what may be presented with respect to a compliance plan, or activities that could reduce the penalty amounts, or those types of things. So.
Okay. AG Davenport had some counsel for us, and then probably what I'm going to do is just go back in the same order and call upon each of you to give us the thoughts for the afternoon, and we'll make sure we all take good notes. So AG Davenport, you have the floor.
Thank you, Mr. Chair. I just wanted to make sure that all of the commissioners were on the same page with the chair's proposal, in the sense that if you do choose the special master route, then what you would still approve whatever comes back to you, that it would come back to you for a vote of the full commission and potentially an opportunity to make changes to whatever comes back to you. But I totally agree that it makes sense to provide some parameters or discussion so that whoever, if the chair is the special master, that the chair is not working blindly in regard to the parameters.
Thank you for that clarification, AG Davenport. Really appreciate that. Okay, Commissioner Gonzalez, do you want to provide some perspective, some thoughts?
Questions first, if that's all right. Yeah. So first of all, I just asked Ms. Larson this, but I'm going to ask it now. Could we get a total of the total penalties that were calculated for these 7 NOAVs? That'd be helpful. My next question is going to be, are we endeavoring to discuss ability to pay at this point? I don't see that as a dependency for a compliance plan down the road or as subsequent to these discussions. So I'm not quite sure where that stands. I guess I want to find out from AG Davenport, what questions do we need to answer still?
Well, let's answer your questions in the order in which they were lodged. Ms. Larson, can you provide all of us with the total penalty assessment that is now finalized? Or AG Davenport, I think, has the number 2.
Sure. Yes, I did quickly take the total penalty for all 7 NOAVs, and according to my pretty quick math, it comes up to $2 million, 14,530.
So 2014530,
which is, one moment. I can provide you, if you have additional questions about what the actual increase was or anything like that, I think I can provide that to you pretty quickly as well.
I just needed the total. Thank you.
In regard to your second question, Commissioner Gonzalez, and I do believe that all of this can be included in sort of a contemplated compliance plan. I see it as whether or not there is still interest in suspending certificates of clearance, some or all, and the timing of that. For example, if that's immediate, or if it is, as Commissioner Messner suggested, a potential consequence of KPK's failure to comply with the compliance plan. Same thing on whether or not there's a suspension of issuing new permits. Corrective actions, specifically in regard to violations found in the NOAVs that you heard in this matter and decided. A larger compliance plan, similar to what both KPK and staff proposed, and sort of a process, as well as what will be included in that larger compliance plan. And finally, ability to pay, and whether or not there's a desire of the commission to just reduce the penalty outright, or if there should be some recognition of ability to pay in kind of a suspension manner. In other words, should KPK meet a compliance benchmark, the penalty could be suspended or vacated a certain amount. Built within the compliance actions of corrective actions, of course, are deadlines. Exactly what that compliance action or corrective action might be. There, I think, probably a variety of little decisions within big decisions throughout all of those things.
Sure. Thank you, Mr. Davenport. Mr. Chair, can I continue?
You certainly can.
Sure. So I guess, does it matter, Mr. Davenport, what order I take that list in?
No. But not to
Okay.
me, but the commissioners may have.
Would it be helpful for commissioners if we put that list up on the screen just so that we're all operating off the same thing? I mean, I just typed up the list, I was taking notes from Kyle. Did you?
I can put it up too.
Can you put it up, AG Davenport?
Yeah, if you can give me a second, I need to send it to this computer.
Okay, hold on. We're emailing from one computer to the next, and then we'll get it up on the screen, and then we'll let you have at it, Mr. Gonzalez.
One moment, please, commissioners. Waiting for it to come through the internet pipeline.
Okay, we're about to see a share screen. Okay.
That work?
Yeah, I think that's good. Okay, Commissioner Gonzalez, the floor is yours.
Thank you, Mr. Chair. So I'm kind of gonna talk through this because my notes combine some of these. They separate some of them. They're in all different orders. But when it comes to what I'm thinking about for a corrective actions and a compliance plan, I think those are necessary. I think those are absolutely necessary, specifically to the NOAVs at issue and the corrective actions associated with those. When it comes to timing and when it comes to what the deadline should be and what the specific execution deliverable should be, I think that should be left up to kind of the parties to come together to determine. And so I think that I'm going to be looking forward to a pretty comprehensive and a pretty aggressive compliance and corrective actions plan. I think that it's important that we set hard deadlines to begin with and that we leave the option open for parties to come meet with us to adjust those as needed. But I think that if we don't put the appropriate deadlines in place and the appropriate aggressive schedule in place to begin with, that we're going to have a lot more of the same, a lot more of finger pointing, a lot more inaction. And for me, getting to the bottom of what we're doing here, I want to see action. I want to see corrective actions. I want to see compliance. And to me, that's more important than the penalties we've assessed in the violations that we have found in this hearing. That being said, I think that there should be the compliance plan. As to the next three, with regard to suspending certificates of clearance, I'm not prepared to do that just yet, or to vote in favor of that just yet. I think that is something that I would like to keep in our quiver for a possibility should the compliance plan not be met. At that point, I think that we could pull that lever to then say, hey, you've had your opportunity, you didn't meet your compliance plan. Now you're not going to be able to sell your products until that compliance plan comes into compliance. So that's what I'm thinking in that regard. So basically holding off on suspending certificates of clearance, as I understand that's something we can do down the line. On the no new permits, I don't think that there's a terrible amount of effect on the operator for this. So I'm not in favor of using that lever for no new permits. It doesn't seem to me like KPK is looking for new permits at this time. And then when it comes to ability to pay, I think this is a really important one. I am not necessarily in favor of reducing payments at this point, but I am in favor of suspending payments, or at least a portion of the penalties, that we've assessed today on the operator. I think that we should take into account what the operator's ability to pay is, and I think they said something to the order of just shy of $900,000. I don't know if that's the right amount or not, and then suspend the rest, or how that looks. But I do think there should be a substantial penalty that the operator should have to pay regardless of the compliance plan, and that beyond that penalty, there should be a suspension of the remainder, and give the operator an incentive to work diligently and aggressively to come into compliance based on what plan we approve as a commission. So that kind of kicking off what's in my head right now, the scheme on how I think this would work, and I'm happy to turn it back over to the rest of the commission for further discussion on that.
Thank you, Commissioner Gonzalez. I recollect the operator's ability to pay number more along the lines of $795, but I'd like us to make sure that that we've got the right number. Does anybody have a different number? We can always bring the applicant back up and just have them tell us their number. I just don't want to be working off of varying numbers. Did you recall, AG Davenport?
Mr. Chair, my recollection is the same as yours, $795,000.
Commissioner Nanjapa, is that what you believe you remember as well?
That's what I have as well. Yeah.
Okay.
Yeah, I think I had 895 in my head, and I didn't find it in my notes. So yeah, that I will acknowledge that number as well.
Okay, so we're just to note that for the record, we're talking 795. However, we end up talking about it. Others that want to weigh in on our list, Commissioner? Okay, I got Messner, McGowan, and Joppa in that order.
Thank you, Mr. Chair. And thank you for going first there, Commissioner Gonzalez, and coming up with a good concept. And I appreciate that. It's somewhat similar to the concept that I came up with. And I'm just going to rattle a few things off here. While I do believe that this operator has engaged in a pattern of violation, I'm not willing to forgo any authority given to this commission by the act to remedy this situation, including suspension of certificates of clearance or suspension of new permits. But I am open to a compliance plan that would require and facilitate this operator both coming into compliance as well as showing an ongoing culture of compliance for the foreseeable future. This compliance plan should include all the remedies suggested by staff with the associated timeframes, acknowledging that there can be some dialogue with KPK. But I do believe that from a regulatory perspective, I think staff has a strong position to be able to suggest appropriate remedies for this particular situation and timeframes associated with those. So I am certainly tempted to, as this commissioner, listen to staff's recommendation. I do believe that it should also include an ongoing compliance and communications aspects that ensures that this operator is able to operate in the state of Colorado in a manner that protects public health, safety, welfare, the environment, and wildlife resources. I do think that this needs to extend beyond the initial compliance of these NOAVs that we've been discussing and into a 3-year compliance plan where they are able to meet the obligations that they're required to meet as an operator in the state of Colorado under the regulation of COGCC. Assuming that this operator is able to meet the obligations present in this compliance plan, I would suggest a suspension of 50% of the associated penalties. Should the operator fail in any way to meet its obligations, then I would suggest the imposition of the entire penalty structure and a suspension of all certificates of clearance and new permits until at such time the operator could prove before this commission that it is come into compliance with its obligations, it is able to operate in a manner that is protective. I think that the suspension of penalty option for a compliance plan does address the operator's ability to pay. I believe that this approach also offers this operator a lifeline. And I truly do hope that Mr. Kaufman, as stated in his testimony, is true, that he truly has reimagined the organizational structure of KPK and will rededicate his company to meeting and exceeding the responsibilities that are required to operate in the state of Colorado in a manner that protects public health, safety, welfare, the environment, and wildlife resources. And that not only he, but the staff working underneath him embrace his statement of owning up to the situation at hand and addressing those situations. I do think that Mr. Axelson's suggestions outside of the submittal that we received from Ms. Stafford today is also an important part of what needs to be included in this compliance plan.
Commissioner McGowan?
Thank you, Mr. Chair, and I appreciate the insight of my fellow commissioners. I think there's some important pieces there that were brought up. I'll try not to be repetitive. I agree with Commissioner Gonzalez that suspending certificates of clearance maybe is something that it's a tool that we don't need to use right now. To Commissioner Messner's point, we give this operator an opportunity to step up to the plate and show us that they can achieve compliance, that they can get to a place where they understand our rules. While I understand that this particular operator isn't necessarily pulling permits for new drilling activities, I do think that they, if I'm understanding correctly, do take on wells that have already been drilled by another operator through some sort of transfers and purchasing. And I think that those should be put on hold until they can show that they can care for the infrastructure that they currently have within their portfolio. I'm not sure that I'm supportive of it adding more infrastructure at this point in time. So while that's not a new permit thing, I would recommend suspending any new transfers to this operator for some sort of time period. I think we need to have some sort of a dashboard that goes with the compliance plan attached to the NOAVs and the corrective actions, and that dashboard needs to have dates and deliverables and assessments, whether it's maybe quarterly, that shows they're meeting those expectations, and if they're not, why that is, and how to get them back on track, or if they can't get back on track. I sense that there's a great frustration with staff feeling that KPK is not
whether communications have broken down or there's kind of this willful disregard for what staff is trying to get the operator to do, I don't know. But I think for the time being, reporting should be to the commission on how compliance is going with, how the deliverables are going with the compliance plan, and maybe that's quarterly to the commission. I think there needs to be some sort of rigorous training component. It is clear to me that staff at KPK either doesn't understand or doesn't want to understand what the requirements are of our rules. I think part of the compliance plan for now needs to have reporting of any spills. Some of the arguments that were going back and forth with staff were KPK's interpretation of our rules and whether or not they applied. And it felt like many of these were around spills. And so for the time being, to err on the side of caution, I think KPK needs to report all spills to our staff so that we know what's going on. And maybe we can start talking to them every time they report a spill and say, oh, this is one you didn't need to. This is an important one we needed to talk about because here are the consequences. Or by the way, the owner also called us about this. And so we're glad that you contacted us to talk about it. I think there, as part of the compliance plan, needs to be better record keeping. There was a lot of testimony about things that KPK said they did, but there were no records to indicate that they had actually been done. And I think there needs to be some component related to record keeping in the compliance plan. And I do think that we're going to have a discussion about ability to pay. I don't know, for me, if that includes putting some amount aside in escrow. If things fall apart, then we have the ability to pull from that account, or I'm not sure yet, but I'd like to have the discussion. And I'm also concerned about, if things fall apart, KPK's ability to deal with the retirement of sites that maybe just simply can't function anymore. And I'd like to discuss increased financial assurance for some of these sites. And maybe that's part of the discussion about a trade-off for ability to pay and suspending some of their penalties.
Okay, thank you. There are three of us feverishly taking notes for all the things you guys are saying. So we will all three be able to look at that. Commissioner Nanjapa.
Thank you, Mr. Chair. Yeah, I also have very similar thoughts to my fellow commissioners here. I would just say that I tend to agree with what Mr. Axelson had said during his testimony, that bringing these sites into compliance is very important, and especially from the perspective of our mission to regulate for the protection of public health, safety, welfare, the environment, and wildlife resources. And so along that same vein, I totally agree that the corrective actions and a compliance plan is paramount. And I think generally I'm happy to hear the sort of change of heart that seems to be exhibited by KPK with respect to wanting to be more attentive and be compliant, and Mr. Kevin Kaufman, in particular, saying the buck stops here. But I also was a little bit troubled that there was a bit of a sense that we can remain in compliance as long as oil prices stay high, and if you hold our hands and help us kind of figure out how to stay on track. And so within this compliance plan, I think it is really incumbent on KPK to conduct their matters and to come back and report to us. So I'm in favor of some sort of quarterly, some tight deadlines and quarterly reporting. I think just personally for me, my leadership style would be sort of to let people go about their business and trust that they're doing the right thing until they give us a reason to not find them trustworthy or to have confidence in what they're doing. And I think, unfortunately, we're there in this case. And so whatever is in the compliance plan should have tight deadlines, strict reporting schedule, and consequences for failing to meet deadlines. Along those lines, I think that this may be something that can be decided in terms of the specifics, but if there's a failure to comply or to move things along with any of these sites, that maybe that would trigger a hearing and potentially broader discussion of all sorts of different consequences, including potentially pulling certificates of clearance, at least for the sites in question. I note that of the sites that we were discussing, I believe there's really only a couple of them that might pertain. For example, the soil spread field would not be a situation of any certificate of clearance issue. But I think that is something that we need to maintain. I also had the same thought with respect to transfers or acquisition of assets. Let's see here. So yeah, I do not believe, so with respect to number one, just being clear that I think that would be something that we would discuss upon a hearing if there was a failure to comply or a failure to keep up with the compliance plan, and that would be one of the potential discussion points. I think that until things come into compliance, no new transfers or acquisitions, and so not specifically the permits for drilling, since that's not really applicable here. I already went through on number 3, and then with respect to ability to pay, my understanding, and without revealing any confidential business information, the information that was shared was based on $60 a barrel, and we're already above that and on an upward trend. So I am less concerned. We also heard directly from Mr. Kaufman that he thought it might even go up to $100 a barrel. And I think that's probably correct. So I would suggest some amount up front of in the neighborhood of at least 500,000. And even though they said that they could potentially pay up to 795, I would bring that down just slightly with the intent of focusing as many resources as possible on bringing everything into compliance. And I would consider suspensions or reductions in lieu of additional projects. And along those lines, some of the projects that I think would be important are some of those that are within Mr. Axelson's compliance suggestions. So like a third-party audit of the flow lines, but I think also a physical audit, walking or drone flying or otherwise mapping their flow lines, immediately investigating any unusual areas of staining, subsidence, dead grass, etc. Over the next at least year, perhaps longer, increased communications with us with respect to how they're moving forward on these activities, and knowing that we probably will have a shorter time frame for the for most of these NOAVs, but understanding that perhaps the Grant tank battery situation may take a bit longer. I don't think we should exclude it from a particular timeline, but maybe include the suggestion that KPK had in general about coming to us within 30 days of the end of a 90-day time frame, requesting an extension for whatever it may be, whether it's Grant tank or other. And I would agree with what Commissioner McGowan also stated about reporting any and all spills, and just in general, communicating with COGCC about anything that they're not sure of, not relying on their own judgment, because as of right now, we are not very confident in their judgment on many of these situations. And I'm sorry to say that, because I'm sure that all the staff is highly intelligent, but I think there has been a demonstration of a disregard of our authority. And so at this point, more increased communication is best, just to confirm that the steps that they're taking or they intend to take are appropriate and should be before they take said steps. Let's see. I think that's it. I think that covers everything for me.
Okay, thank you, commissioners. I'm in general agreement with everything that I've heard. Let me see if I can get some consensus around some of the issues that some of you spoke to that the others did not. What about the time of the compliance plan? Commissioner Messner mentioned 3 years. Is that a time that folks can get their hands around? Perhaps 3 years, and you know, maybe it becomes lessened upon hearing if they're able to show that they're in compliance and that they're operating. What are folks' thoughts on that? And then I'm going to ask a couple other questions as well. Commissioner Gonzalez.
Thanks, Chair. I don't know that 3 years is inappropriate. It seems like a long time to me when I kind of first heard it proposed. I think that we're going to know pretty quickly in a year, maybe 18 months, maybe 2 years, on if this compliance plan is being adhered to, if progress is being made, and if changes are occurring at KPK. I would maybe suggest that maybe it's a tapered plan that shoots for 3 years. And when I'm saying tapered, I'm talking about maybe the frequency with which, excuse me, they report to us on their compliance plan or on their entering compliance, where perhaps it is quarterly, then it is, I don't know, maybe it's monthly, then quarterly, then semi-annually or something. But anyways, that's kind of the way I was thinking about it. I think to hear from KPK on their compliance plan regularly for 3 years may be a bit excessive. So that's just kind of my thoughts on it. I haven't fallen one way or another, but that's just one of the things that's kind of popped in my head about the length of it.
Commissioner Messner.
Thank you, Mr. Chair. And just to put a little more color on my thoughts around that, I mean, understand that I do believe that the initial compliance to the NOAVs needs to sit within that 90-day or less time frame, right? When I talk about the compliance plan, certainly the reporting piece, like Commissioner Gonzalez indicated, is there, but also that they are not violating COGCC rules for 3 years, right? And so that they stay in compliance for 3 years is really the emphasis of it. But the reporting piece is important as well. And I don't have a problem with tapering down those reporting requirements, assuming that they are in compliance.
Commissioner Nanjapa, or Bill, did you want to respond?
Yeah, just that, you know, I guess I don't quite understand, and this may be a part of the compliance plan, so this is going to be, again, one of these topics that we're going to talk about here that may get fleshed out after this date. But basically, I guess I don't quite understand what the consequence would be other than an NOAV for the operator being out of compliance for 3 years. Or are we suspending this penalty for 3 years as we've kind of contemplated the suspension? Is that suspension to occur for 3 years, in which case any violation of any order, permit, or rule would crash that forward and obligate the operator to pay that full amount? I'm just not quite sure I understand what staying in compliance with all the rules is for 3 years, what that means and what the consequences may be. So Commissioner Messner, I'd love it if you'd help color that in for us.
Desire to
your
color,
thoughts?
Commissioner Messner.
Thank you, Mr. Chair. And you know, I do think that some details certainly can get worked out. But to me, what it means is, yes, that penalty would be suspended for 3 years, assuming that the operator can stay in compliance with the compliance plan for those 3 years. Then that would, at the end of 3 years, then that penalty would be permanently suspended. Should the operator not be in compliance during that 3 years or receive NOAVs, then that penalty at that point would be imposed, as well as potentially the rest of the tools that are available to the COGCC to either suspend certificates of clearance or suspend future permitting authority from this particular operator. So it does not limit the tools that are available to this commission for that 3-year period.
Commissioner McGowan, I can't remember who's next. So Commissioner Nanjapa, I apologize. Go ahead.
Are we saying we want the operator to be in compliance with the compliance plan for 3 years, or the operator to be in compliance with all rules, with all their activities? I just need some clarification there. And then Commissioner Messner, are you suggesting that the entire penalty is put on pause for the 3 years, and if they meet all of the expectations, then there's no penalty at all related to this? Sorry, I hope I'm misunderstanding.
And again, AG Davenport just whispered in my ear that, we're not making a decision finally at all today. What we're trying to do is generate direction so that the operator has perspective on what will be needed, but the details would be fleshed out. So with that caveat, Commissioner Messner unmuted himself and he started this discussion, so I'll let him respond.
Yeah, so for me, the proposal would be a suspension of 50% of the associated penalties, assuming that they are compliant with both the performance plan or the compliance plan, as well as did not have any additional compliance issues. To me, that's part of the compliance plan, but that you would not have additional NOAVs issued for the period of 3 years for noncompliance to COGCC rules. And so, did I answer all your questions? So 50% of the overall penalty amount. So it's essentially a reduction of $1 million. The penalty would still be assessed $1 million, but this other $1 million would be suspended until they completed the 3-year performance plan. And at that point, it would be permanently suspended, that remaining $1 million.
Thanks for the additional color from Commissioner Messner. Commissioner McGowan, follow up.
Thank you, Mr. Chair. Only that I'll go back to a comment that I made before, which is I think when an operator has many sites, there will be some issues, unanticipated problems, perhaps. And for me, to expect that an operator isn't going to have any, I guess there's a difference between a violation and I'm trying to just figure out for 3 years, is it realistic to say that an operator will have no NOAVs? I see what you're saying. I think I need to noodle it a little bit. Thank you. Sorry.
That's fine. I tend to agree with that thought process, Commissioner McGowan, is that, we need to establish something that is doable. So, that'll be my comment on that. Commissioner, and I see Commissioner Gonzalez is shaking his head up and down, so I'm going to put him in that category as well. Commissioner Nanjapa, I recognize you.
Thank you, Mr. Chair. Yeah, I mean, I think I appreciate the notion. I think what the sidebars are for that sort of 3 years of compliance, need to be specified. I'm generally okay with that conceptually, and I just wanted to clarify because I don't know if I said, but I am thinking a portion of the penalty paid this year and then a larger amount paid in subsequent years, and perhaps that comes out to a 3-year payment plan. But of the full penalty amount, unless some of the projects that we discussed, if they elected to complete those, then there could be a reduction. If that makes sense.
Commissioner Gonzalez.
That makes sense to me, Commissioner Nanjapa, and thank you, Mr. Chair. I think the way I was thinking about it is that it's, if we're talking about a 3-year probation for a suspended penalty and we're expecting perfection over 3 years and no violations of rules, I think that's a little excessive in my mind. I think that there's ways to do it where we could still create that incentive for the duration of a compliance plan, be it 3 years or a different amount of time. And I would throw it out for consideration. Perhaps we take a set amount that's a penalty due, because again, I believe there should be a penalty paid for these violations now, and then we suspend the remainder of that. And with that suspension of the remainder of it, I think a good majority of that remainder should be tied to bringing the specifically identified locations into compliance, and then have some minority amount of that suspended remainder broken up through either maybe a 3-year track record of no violations, maybe a demonstration of updated policies. And then I think that's a way that maybe we could, pretending I'm Commissioner McGowan for a second to split the baby there. But I think that's an opportunity maybe that we could spread it out in a fair way that doesn't just have an operator going through all the steps, bringing their locations into compliance, doing all the right things, and then in 2 years and 364 days, someone doesn't get a form in, or there's something outside their control that's a violation. They do everything they can to remedy, and it's still a violation, right? There's still violations that occur when operators are still operating, squeaky clean. So that'd be kind of one way that I would think that I may be able to get on board with what that compliance plan may look like in reference to how we apply and how we adjudicate the suspended penalties. I would also suggest that if at any point an operator does become in violation of that compliance plan, or whatever we say to I guess remove the suspension and impose those suspended penalties, that we as the commission should hear that and hear the matters and hear the circumstances regarding that, to make sure that it's not automatic and that we're applying the appropriate level of scrutiny on that decision. So that's kind of to fill out my answer in response to Commissioner Messner's suggestion.
Thank you, Commissioner Gonzalez. I tend to agree with the points you just made. So I think maybe, well, let me ask a couple more questions so that I can get consensus on things. Commissioner Gonzalez, Commissioner Messner, what are your thoughts about prohibition of transfers?
Mr. Chair?
You're up.
Yep. I am comfortable with a prohibition of transfers into KPK. I'm not quite sure how I feel about transfers out of KPK. I may suggest, just given the unique situation that we're faced with here with the pattern of violations of this particular operator, and perhaps even some of the suggestions we've heard from stakeholders in regards to putting off transfers pending financial assurance rulemaking next January, is that for this particular operator, I would support a suspension of transfers into KPK. I do not think that they should take on additional assets and additional operations until they can prove their ability to comply with our rules, orders, and permits. I think I would also, and I'm still thinking through this, I'm not quite there yet, but I think I could also consider perhaps a moratorium on transfers out of KPK without or subject to commissioner review until the contemplated financial assurance rules come into effect with regards to such transfers. So that's kind of where I sit in that, just to clarify kind of the transfers in and out perspective, and not just lumping it all into transfers.
Commissioner Gonzalez, while I've got you, let me ask you another question. Report all spills?
Yes, I think that would be good practice, at least for the first year. I think that'd be appropriate. I think that KPK needs some practice to understand what the commission is going to consider a spill. I also think that if I was an operator and if I was KPK, I would report all spills for a little while, just to make sure that my entire team understands what forms are necessary, when they're necessary, how the reporting should occur, when the reporting should occur, and just understand that process to the point where there can be no mistakes like we've seen in the NOAVs that have been before us in this hearing.
Okay, Commissioner Messner, transfers and spills.
I'm on board with Commissioner Gonzalez's suggestions.
Okay, I think that gives, so I think I've gotten like consensus around many of the wonderful, the good issues that you guys have raised. I think the only thing and I'm looking at Hearings Manager Larson and AAG Davenport, if you see an area that we need to further get consensus on. The only thing that seems to be outstanding to me right now is can we get to consensus on the penalty that we want to impose now versus the penalty that's suspended? Or, I mean, do we want to try to do that today? Commissioner Gonzalez.
I think that's appropriate, Mr. Chair.
Thumbs up from everybody else. All right, Commissioner Gonzalez, I'm going to let you go first.
So I'm pretty close to where Commissioner Messner is. I think that the KPK has demonstrated an ability to pay a certain amount. We mentioned that amount earlier. I apologize if I delved into something that may have been confidential from executive session. So that's on me, and I apologize. But the amount that was testified to by their forensic accountant would be the amount that I suggest we apply as the initial penalty to be paid at this point. And if I don't believe that contemplated the necessity for a payment plan, but I would contemplate that should KPK need that. I think that would be an appropriate topic for our consideration at the very least. And so that's kind of where I sit, and then suspend the remainder of the penalty.
Okay, Commissioner Messner.
Thank you, Mr. Chair. I think that's appropriate. Just to make sure I understand, Commissioner Gonzalez, you're suggesting essentially a 50% suspension of payment, and then some graduated ability to be able to suspend the rest of it. Is that right?
Yeah, not quite 50%, but but close to that. And I think that what that graduation looks like for how it gets tapered off. Again, I suggest the majority of that suspended amount should be tied to specific corrective actions, and that a smaller minority should be tied to a compliance plan or some sort of compliance probation that lasts the remainder of whatever that compliance plan is determined to be in effect for.
Okay. I mean, I can get on board with the graduated concept, but I do think that the 50% is appropriate. So.
Okay, and AAG Davenport just whispered in my ear again, we're getting your perspective now, but we're not, and that'll help in terms of figuring this out, in terms of bringing something back, but you're not bound to this. And so, like the payment upfront penalty needs to be, how did you say it, AAG Davenport? We need to like think about it in terms of the compliance plan and bars that are met and things of that sort. So again, it helps give perspective as we move into the next step of figuring this out. Commissioner Gonzalez, please.
Yeah, just one more thing, Chair. If we're not going to be deciding on an amount of penalty absent the compliance plan, or I guess subject to a suspension for the compliance plan, I just want to make sure that as one commissioner, I think this penalty that should be paid, the portion that would not be suspended should be meaningful to the operator. And so, what that comes out to, I know will come to us for approval, but I would like to at least set that in the minds of the parties and of the potential special master, that's what I would be looking for.
And I think Commissioner Messner would agree. Okay, Commissioner Nanjapa.
I'm comfortable with something along those lines. My, initial suggestion was something a little bit lower as a upfront payment, simply because I want to really see them devoting their resources to bringing all the sites to compliance. And to the extent that, that would help. But otherwise I'm in favor with either, I actually believe that bringing these sites into compliance is what they were obligated to do no matter what. And so I think that the penalty should not necessarily be suspended, but they should be given a bit more time to pay it. But as noted before, perhaps offer some concessions, reductions with special projects that would help them get better on top of their infrastructure, get us better on top of all of that, and be able to, understand kind of what all their assets are, what the conditions are, and help prevent some of these issues going forward. I also just wanted to note about Commissioner McGowan's suggestion on training. I think that would be important in a compliance plan. One last point, if I may, Mr. Chair, that I don't think I noted before. With these open sites that we're trying to return to compliance, I think, especially those with the open excavations, I think a real priority would be to ensure that there's good fencing and, protection and storage or management of E&P waste in particular, as they continue doing whatever they need to do with respect to the excavation or the soil testing or whatever. And I wanted to make a note that I just wanted to have a better understanding of what the issue was with respect to the soil boring that KPK was requesting, to better understand the extent of the grant tank matter, and just as a point in the compliance plan that I think would be important to make sure that the staff, whoever is managing this matter, that is something that is addressed specifically in the compliance plan as part of kind of getting that site into in order, and just ensuring that we have protections in place for those open excavations.
Thank you for that, Commissioner Nanjapa. Commissioner McGowan, do you want to weigh in on the penalty aspect at this time?
So I'm supportive of suspending a portion of it based on ability to pay. What that amount is exactly, I think at minimum it should be the amount that the financial forensic person shared with us in our executive session at minimum. And I think they're probably going to need a payment plan, and I'm okay with it.
So, Commissioner McGowan, can I follow up? I'm not sure that Mimi and I followed your point there. So you started about willing to suspend, and that maybe that should be the amount that the financial guy told us. But I guess
the amount to pay should be what we discussed in executive session.
And with a payment plan if needed.
The payment plan. And the suspended amount
would be the rest.
Tied to performance and the compliance in the performance plan or the compliance plan. I'm supportive of all those things.
Okay, thank you. That's kind of where I am too. So I think I've got good direction on penalty and suspension. Commissioner Messner?
Thank you, Mr. Chair. I just wanted to make sure, and I think, I think I said this and I think it was understood, but when I had referenced the plan that was provided by Mr. Axelson, it was the one that included the flow line and production equipment, written maintenance, repair and replacement plan, the comprehensive waste management plan, the spill and release reporting plan, and the and the implementation plan for all ongoing unresolved remediation projects. So just to be clear on that, I'm not sure if I was clear or not.
Okay, that's clear in my notes. Okay, what other thoughts this afternoon for direction for Ms. Larson, Mr. Davenport, and myself, and then we'll try to capture all of our notes, and we'll try to sync it up so that we're, getting the pieces and putting them into buckets, right? So that we have a sense of direction. Okay, I'm not seeing anything further. With that, and just sort of go back through where we are. So we found today a pattern of violations. We found today a total penalty of $2,014,530. We have identified the important elements for corrective actions and a compliance plan from commissioners. And we will, I think, allow me to get in the room with KPK and staff to create, hopefully, a compliance plan and a corrective action plan, and that we would then come back to commission as soon as we can, not knowing how long that would take. And that would also give staff the ability to do inspections to make sure their corrective action plan that they told us about today is indeed inclusive. AG Davenport, am I missing anything? Do we, from your perspective, or this is a new rodeo for us, but I think we've done a fairly good job of getting through all of this today. And do we need to, if we're going to continue this matter to allow for these actions to take place, you're going to continue it for, to a date certain so that we don't have to renotice it? Now I'm looking at you as a question.
Yes, so unlike rulemaking, I think it can be continued until the commission receives notice from you that you're ready, you and the parties are ready to present a completed compliance plan, et cetera, to the commission.
So what would you suggest we do right now?
I'd suggest two things. Well, three things, actually. I'd suggest a motion, first of all, to appoint you. And for the commission's edification, the act does authorize the commission to appoint a member of the commission as a hearing officer. And hearing officers have the authority to do what we've been discussing, appointing the chair to do today. So I would suggest a motion to appoint Chair Robbins to act as a hearing officer in this matter, to, struggling for the right word, to mediate or confer with the parties in regard to compliance plan and penalty amounts as discussed by the commission today. That's the first thing I'd suggest.
Okay, then what are your next two suggestions, and then we'll take them in order.
Then I'd suggest a motion to either continue this matter to a specific date or until you, as that hearing officer, are able to notify the commission that you're ready for them to see that worked up plan.
Okay.
And then finally, a motion to adjourn.
Commissioner Gonzalez.
Thank you, Mr. Chair. How much time do you think we're going to need for coming back?
6 weeks. 7 days.
I was thinking 6 weeks was a little long.
How about I want to give a reasonable amount of time. I think 7 days is too soon. I agree 6 weeks is too long. What if we say 3 weeks?
Can I offer a counter?
Yeah.
What if we did 2 weeks and then give us a week to really dig in and contemplate the draft that you and the parties come up with?
Okay.
And then we can meet on a date certain, we can deliberate, we can hammer it all out.
Mr.
Oh, go ahead.
Sorry. Okay, we'll try this again.
Okay.
I'm not sure why there was the echo. If I may, I believe one of the elements that you had contemplated being in the plan would allow staff to go out and re-inspect some of these sites. So perhaps 2 weeks might be a little aggressive to allow staff to get out to the sites to conduct the inspections, to have enough time to report back to you and to the parties as to what the results of those inspections are.
Commissioner Messner?
Thank you, Mr. Chair. I will note that in the compliance plan that was presented by staff, some of those timelines are already pretty tight as far as what they feel like needs to be remediated in what timeframes, including one, I believe, that was around the 8th of October that needed to be accomplished. And so that's why I'm suggesting a tight turnaround on this. I think this is, we're talking about sites that need to be remediated. They need to be remediated quickly. And so I would really encourage us to run as tight a ship as is feasible to be able to do.
Why don't we, so I'm just looking at my calendar. We're at the 21st. 1 week gets us to the 28th. 2 weeks gets us to the 5th. Why don't we set a special hearing for October 7th, which is 2 weeks and a couple days. And so let's just move to continue this to October 7th at 9 a.m. And then we'll see where we are. Okay, so I think we're first looking for the motion to appoint me as hearing officer to undertake the matters that we've discussed.
Mr. Chair, I'll make a motion to appoint Chairman Robbins, yourself, as hearing officer in this matter to facilitate the development of a compliance plan.
Second.
Okay, we have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Aye. Motion carries. Next, we're looking for a motion to continue this matter to 9 a.m. October 7th.
So moved.
Second.
All those in favor signify by saying aye.
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 Any opposed? Lastly, we're looking for a motion to adjourn.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
All right. Commissioners, very good work today. And thank you again to staff and to the parties, the council for KPK. We will be in touch and we will see everybody tomorrow morning at 9:30 for our normal weekly hearing. Is that right, Ms. Larson?
That is correct.
Okay. We are adjourned.